Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mischegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Good morning. Happy Thursday. Today is Thursday, February 27th of 2025. And what the duck? We're still here. We're still covering the Karen Read case. The re-persecution of Karen Read, supposed to scheduled to start on April Fool's Day, which is kind of ironic, but not really. It's actually kind of fitting. How's everyone today? I just read in the New York Post, because, that's where I get my alerts from, that Gene Hackman and his wife were found dead in their home. And they're saying it may be carbon monoxide poisoning. I don't know. I think that's 3, because we were talking about celebrity deaths happening in 3s. And yesterday, I learned that Michelle Trachtenberg has passed away. She apparently had a liver transplant recently. Michelle Trachtenberg of Gossip Girl fame. She was Georgina Sparks on Gossip Girl and also had been on Buffy the Vampire Slayer, and also may or may not have been somehow abused by Joss Whedon, who was the director of Buffy the Vampire Slayer. So very sad on many levels. I think Michelle Trachtenberg was in her 30s. Very sad. So Gene Hackman's daughter, wife, and dog, I think, were all found dead this morning. Where do they live? They live in New Mexico. Michelle Trachtenberg was 29. Very sad. They're saying it was complications from a liver transplant. I don't know. They're saying it may be natural causes. Nobody ever got the real full story about what her accusations, I think, against Joss Whedon were. And there were many other people who also had accusations against him. But that's a story for another day. Very sad. Oh, yeah, we're not going to talk about that C word, God's tender mercies, because YouTube doesn't like that word in the chat. And there are people who have been banned from YouTube for saying that panty word that begins with a C. So please don't do that. Thank you so much. The mods are on it this morning. It's over 2,000 of you in here. So many of you have been asking me questions about this federal lateral appeal. And I have a special guest on to break it down with me, because he's done a couple of shows on it and he knows a lot more about federal constitutional law and procedure than I do. And so instead of me learning it all, I'm going to bring him on in a couple of minutes. But first, let's talk about the defense motion to dismiss for extraordinary governmental misconduct, which we know was filed on Friday because that was the deadline. We did a couple shows over the weekend talking about it. And we know also that the defense filed a motion to impound certain portions of that motion as being part of a federal protective order. And not only did the defense submit a redacted copy of the motion, but also an unredacted copy of the motion, We also know that it was not docketed. It wasn't put into the system until yesterday, which is coincidentally after that hearing on Tuesday, and also after the weekend, because they didn't want us talking about it clearly. And so I don't know if it's going to be unsealed at some point once the judge decides whether or not she wants to release the redacted version. But we also know that when Brennan made his motion for sanctions, which has not been heard yet, by the way, that one of the areas of relief that he wanted or suggested to the judge was that everything that the defense files from here on out should be impounded until the Commonwealth has a chance to look at it, and the judge. So the Commonwealth wants to police the defense now. And as far as I know, she hasn't granted that motion for sanctions, and because she hasn't even heard it yet. I don't know, but I made a community post about that yesterday. So many of you were outraged, as always, because just when you think it can't get any more outrageous, it gets more outrageous. Also, I have some new merch to show you. For those of you who know the lore, you know the lore. So I thought this was fun. I had a little fun on Canva yesterday. And you guys remember, well, you may remember from just a couple of weeks ago when I went to Cancun to see Dave Matthews, right? And I did some live streaming from there, and you guys, some of you who were interested in it, watched it with me, and it was fun. It was like we were all in Cancun together. What some of you may not know about that lore is that a year before, so exactly a year ago, I think it was last February 2024, I also went to Cancun to see Dave Matthews and Tim Reynolds on the beach because they do it every year. And while we were covering one of the Karen Reed hearings, I commented that Alan Jackson had a bracelet on, kind of like this rope bracelet that looked like something that I bought in Cancun. I'm like, oh, that's so funny. I think I have the same bracelet. I wonder if he was in Cancun at Dave Matthews too. Well, the Twidiots got a hold of that one, and it morphed into this thing that I was in Cancun with Alan Jackson. Do you guys remember that? And then, like, that rumor had so much legs, apparently, for the Twidiots, that Grant Smith Ellis one day, while Alan Jackson was walking into the courtroom, actually chased Alan Jackson down with his microphone and said, "Alan Jackson, did you have fun with Melanie Little in Cancun?" And like shoved the mic in his face, like twice, like chased him up the courthouse steps about it. And that was wild. And I remember when it first came out, I was like, I can't believe that they're saying this. This is so crazy. And my friends were like, girl, if somebody thought that I was like in Cancun with Alan Jackson, I'd be owning that shit. Like I would love it. You should. And kind of funny, but so, why not? If you know, right? So here's some new merch for you guys. Hang on. Dun, dun, dun. You too can get your own. Well, this is the sticker. I went to Cancun with attorney Melanie Little, established in 2024. There you go, friends. There you go. You can thank me later. I went to Cancun with Melanie Little. There's very few people who can actually say that and mean it. Cool sweatshirts. Look, isn't that nice? Do you love it? Tell me, do you love it? Yeah, we got mugs. These are the Bella and Canvas sweatshirts are great because they're so soft. They're so soft, and I just love them. And so, why not? Some of you actually did go to Cancun with me because you were there when we did the live stream, right? I went to Cancun with attorney Melanie Little. So that was one fun thing that I did on Canva. It comes in a couple of different colors. I didn't put the colors in there that I didn't think looked good on it. So then there's just a men's black tee, and I think it comes in maybe a couple of colors. Let's see. I mean, fun, right? It would be funny if Alan Jackson got one. I actually should get him one. I should get him one and send it to him, right? And then I even made there's a cool, they have some cool products. This is Spread Shop. A lot of people use Teespring, but I heard Teespring's customer service and stuff wasn't very good. So this is Spread Shop. I really don't mark these things up. I don't make any money on this stuff. I just thought it was cute. This is Under Armour. Isn't that cute? And then that has a little less obvious sort of logo on the left side of the lapel, right? So that's fun. Yeah, I saw that. CM Libby. The Boston Herald incorrectly reported that the redacted copy will be posted once they have that, but they both were submitted at the same time. Yes. And I thought that too. When my first gut reaction, my gut punch reaction when I read that article in the Herald, which we can go over later, is that they're wrong. You wrong. However, I think maybe perhaps that the judge might want to look at it and make sure that she's in agreement with what they actually did redact. And wait, I have one more design. I was thinking about having like a merch contest because I'm like really not good at doing this, but hang on, let's see. One other design because it was, you guys requested it. Okay, so here's this. I mean, I thought we had to get something that said free Karen Read on it, right? So this one, it says free Karen Read on the front. And then on the back, right, on the back, it says this: we are outraged. Stay cool, stay kind, stay classy. Attorney Melanie Little. And there's a couple of different products with that design on it as well. There's a hoodie. Let's see. Oh, and there's even a pink hoodie for those of you who like the pink hoodie. I just don't know if the design is so great on the back. So what I'm going to do, I think the link to the shop is like in the comments, but yeah, we need a what the duck. Yep. You guys email me. Oh, here, this is a nice, I like this pink hoodie too. I like this pink color. Also comes in yellow. Yeah, the double-sided. Yeah, so I was thinking maybe I would make some with I went to Cancun with Melanie Little on the back and then put the free Karen Read on the front. You know, I'm open to suggestions. I mean, it's all about you guys, what you guys want. So the prices aren't too bad. I may even be able to lower them a little bit. Like this is a cool hoodie too, I thought. With the back. You know, a girl's gotta have options, right? Yeah, I agree. The Maya sweatshirts came from the same company and they were good quality. So if you look for the Bella and Canvas stuff, it's softer and it is, I think, higher quality. So that's fun. We'll always have Cancun, Bernie. We will always have Cancun. And you guys were there with me this year, so it is kind of fun, right? All right. Let me you know what? Let me just put the link. I'll pin the link in the chat. How's that? If you want to wait, I think there's a sale coming up. Occasionally they do these sales and they're like 15% off. So there you go. There you go. We got options. I think that's the right link. Somebody just check the link and make sure it works. No, I got to pin it. Boop. I thought maybe we should also, you know, make some merch that says the world is watching, something like that, you know? I have some I have the I am not a cupcake logo, but it was like it didn't print right and I needed a better version of it. I have the what say you with the cupcake with the line through it. And I have the come for me in the comments, which I used to say in the beginning of the show that I don't say so much anymore. Oh, also I have the it strains credulity, which is the Alice in Wonderland. So that's this one. It strains credulity. So there's that, right? Oh, it works. Okay, cool. All right, great. I know sometimes retail therapy is always a good thing, right, you guys? Always a good thing. Also, today there's a 2:00 hearing on Brian Walsh, which I would like to cover. So I hope you guys are interested in seeing that because we're going to, I'd like to cover that too. All right. But in the meantime, I know you guys have a lot of questions about the federal habeas petition. It's not meaning who does the shipping. It's Spread Shop. I think they do ship to Europe because they always ask me if I want to translate it into other languages. So I'm pretty sure that they do. I'm just going to tell you right now, disclaimer, I don't have anything to do with the printing or the shipping. It's not Amazon. Like it's not getting to you in 2 days. But it will get to you like within a week. So as long as you don't need it for like tomorrow, you should be good. Okay. Okay. Yeah, so I don't know. Thank you. Thank you, Melissa, for watching from Australia. I don't know. I think they do. If anybody wants to click on the link and check it out, thank you so much for your super chat. You're awesome. All right. His daughter was not deceased. No, his daughter found them, I think, Gene Hackman and his wife and the dog. Yes, I'm Brian Walsh. Okay, that's 2 p.m. I'm going to bring Kurt up from Uncivil Law because he is the king of, knowing law and federal procedure and all that kind of stuff that I don't have the time to learn about or review, but he does, and he's done it already, and he's here to answer your questions. So get your questions ready for Kurt. Hi, Kurt. Uncivil Law is here, everyone.
How you doing, Melanie? It's nice to be here.
Oh, thank you. I don't have like an applause thing like Will the Glare.
That's okay. I feel it in my heart.
Oh, good. I'm so glad. Talk to us. Well, first of all, they lost the appeal at the highest level of Massachusetts Supreme Judicial Court. The SJC lost the appeal. They didn't want to overturn the judge. They didn't care about the arguments. They just don't care. So now they have filed this writ of habeas corpus in federal court in Massachusetts. And perhaps you can talk to me like I'm 5 and tell me and the viewers who may know more, what is a writ of habeas corpus? What does that even mean?
Sure. So I'll walk everyone through the basics. So a writ of habeas corpus is a collateral attack. We're attacking the case from the side. So many articles will refer to this as an appeal, but strictly speaking, that's not correct. This is not an appeal. This is a collateral attack. We've brought a completely new lawsuit in federal court. This is not Commonwealth versus Reed. This is Reed versus the court.
Right.
And Reed versus the Attorney General, right? So it's a new lawsuit within its own parameters. And that's important for a couple reasons, not the least of which is because all the record that exists in state court doesn't exist until it's brought into the federal proceeding. The federal proceeding is only based on what's presented to the federal court, like any case happens. So as we're trying to decide what we think is likely to happen, we have to remember there is no record except what is explicitly brought into the federal proceeding. So that's one of the reasons that's important, as opposed to an appeal where, of course, the record carries at every level.
Right. And that's why it was 700 pages, because something like 650 of those pages was the record on appeal.
Right. Exactly so. So that's an important detail. And now habeas relief is basically produce the body, is what habeas corpus literally means, produce the body. More to the point, why am I being held? Why am I being prosecuted? I'd really prefer not to be in prison. I'd really prefer not to be prosecuted very much. This is a violation of my rights. And of course, it's protected by the US Constitution. And exactly what habeas means, of course, is defined by federal law, as it would have to be, because it's part of the federal Constitution. Right. So what the parameters of that look like is defined by federal law. Typically, they tend to be a more constrained proceeding. They typically tend to look for specific issues. They don't try to look at things as a whole. They try to look for a very specific thing and try to go after that. So that's where the first procedural posture of the thing.
Okay, so technically, even though she's not imprisoned, or in jail awaiting trial, she's still considered to be in custody because she's under bail conditions and has certain like restrictions around that.
Yeah, she's in custody enough for the purpose of habeas review.
Okay,
it's both parties seem to agree on that much.
Yeah. All right. So
nice.
Tell us about what the basis for this is, and what the cases say. And I guess they filed a response yesterday.
They did file a response, and I looked at it and I discussed the response. Okay. And I've also looked at some further issues since then. And so I'm bouncing back and forth on this issue because it's actually really interesting in terms of the legal posture. So I have some cases that I have. And so we can just start with, first of all, whether the federal court will actually even hear this case at all. That's sort of place number one to start. So if you can,
okay, cool. So everyone, there is a conference scheduled for, I think it's next Tuesday or Wednesday, because I know it's the same day that we're supposed to be in court on Karen Reed, and we're in there both Tuesday and Wednesday. And Alan Jackson has been admitted pro hoc vice into federal court for this proceeding, but they're not arguing it next week, right? This is a conference.
Yeah, well, that could manifest in a lot of different ways.
Okay.
So that could manifest in presentation of things. It could manifest in it depends where it kind of goes, where it goes. So, and also, of course, the federal court is aware there's a time crunch here because there's this April 1st sort of ticking clock in the background. So I wouldn't be surprised if the 5th turns into more substantive than it might otherwise in a normal case.
Okay. So they should be ready to argue in case that's what they're
I would be. I'd be ready to argue this on the merits when I show up. I'll tell you what.
Right.
All right. So we can start with a very famous case in U.S. constitutional law called Ex parte Young. Big foundational case, and this relates to this idea of the federal court abstaining from hearing certain kinds of cases. Like, even if the federal court technically can, sometimes they just don't because of policy reasons. One of those being that the idea of separate sovereigns is a big deal. We work in a federalist system. The state of Massachusetts is sovereign. The US federal government is sovereign. So we have this dual sovereignty. And the federal government wants to respect the sovereignty of Massachusetts within its own respect, because it has that sovereignty aspect. So this case just kind of highlights the issue. It's obviously not the only case that talks about abstention. There's Rooker-Feldman. There's other cases to speak about it, but I just thought I'd bring this case up for just the idea. So I highlighted a little language here from Ex parte Young. This is Supreme Court of the United States, 1908. They write, further objected that a court of equity has no jurisdiction to enjoin, in other words, stop a criminal proceeding by indictment or otherwise under state law. This is true, but there are exceptions. And then they write, but the federal court cannot, of course, interfere in a state where proceedings are already pending in state court. Now, despite that language, that last sentence, as I mentioned, there have been other cases since then that make it not quite as absolute. But there is a non-zero chance that, despite the fact that there are hearings already scheduled, and the court might in fact have many hearings, that in the end, they'll decide that they don't want to hear the case.
That's a possibility.
That they're going to abstain from hearing the case. So despite the fact that there are hearings scheduled and they're going to things, in the end, they might be like, we're just not going to get involved. So that's sort of one thing. I don't think that's going to apply here, but since it's a non-zero chance, I figured I'd highlight it just in case it popped up.
Sure.
Okay, great. All right, so we now turn our attention to this First Circuit Court of a case. This is Gonzalez versus Justice of Municipal Court. This is First Circuit Court of Appeals, where Massachusetts is, which of course is important when we're dealing with precedent, because the First Circuit controls Massachusetts. So if this were a Ninth Circuit case, for example, coming out of California, it would only be persuasive authority. Because it's a First Circuit case, it's binding authority on the First Circuit, on the federal court. So that's important.
So they got to follow it.
So one of the things that the First Circuit was trying to decide in this case is whether this law called the Anti-Terrorism and Effective Death Penalty Act applied to the kind of proceedings that Karen Reed is trying to bring. So this law, the Anti-Terrorism and Effective Death Penalty Act, kicks in principally when you're already convicted and serving time. And it makes it very, very difficult for the federal court to grant review. In fact, they will only grant review if there is clearly established law by the US Supreme Court. So it's incredibly constrained review when there's already conviction. Now, in this case, they were trying to decide whether that principle applies when there hasn't been a conviction, like there hasn't here. She hasn't been convicted. So does it apply? So I highlight some language to do that. So they say in 1996, ADEPA, the Anti-Terrorism and Effective Death Penalty Act, what a mouthful, particularized a framework for adjudicating certain habeas corpus cases. That mode of review is quite respectful to state court judgments. That's an understatement. Quite respectful. Yeah, that's an understatement. The Supreme Court recently reaffirmed the well-settled rule that Congress includes particular language in one section of statute, but omits it in another section of the same act. It's generally presumed that Congress acts intentionally and purposely in the inclusion or exclusion. So if Congress writes something in one section of the law, but not another section of the law when they're dealing with the same thing, one of the things that Congress might be indicating is they only want that thing for that particular section. So as we're trying to understand the statute as a whole, and Congress writes this language, one of the things might be, does this apply globally or does it only apply here? And so this basically is like, okay, Congress is a smart Congress. That's the premise we're going with, okay? That's the premise we're going with. You have to buy in. Congress is a smart Congress, and they know what they're doing, and they're acting purposefully. And when they write things, it's because they know what they want. Cool, great. So when they wrote this language, they probably didn't want it to apply to the other section. So the court continues to write, that principle militates strongly in favor of a conclusion that ADEPA's review standards, which are basically borderline impossible in the event that you're already convicted, should govern only those habeas petitions that relate to already convicted. They do note, however, there is a circuit split on this issue, which always makes things interesting, because anytime there's a circuit split, you always are thinking US Supreme Court could get involved. So the 10th Circuit doesn't agree. So if we're in Colorado, they don't actually agree with this principle.
Let's go Buffs.
They're different. But anyways, they write that despite the logic of this, the only court of appeals that appears to have confronted it simply applied a DEPA to this circumstance, the 2241 petition, which is what Karen Reed is doing. And then they say, with respect, we're inclined to believe this approach is incorrect and that Section 2241 maintains its posture. So the First Circuit disagrees with the 10th Circuit, which of course happens many times in law. That's the way that goes. And so they say, as a matter of First Circuit law, we want to evoke de novo review as the state court's conclusion of law. Thus, we proceed on the assumption we, as a federal habeas court reviewing a petition under 2241, must defer to the court's findings of fact, but must undertake plenary review of the court's resolution of law. So the reason I make that point is because this is actually really good language for Karen Reed. Right? This is incredibly good language for Karen Reed, because if she was stuck under a DEPA, there's really no U.S. Supreme Court case that would work here for her. But there is a First Circuit case that has some potential. So because she's not stuck under a DEPA and she has more flexibility, she has a chance. So that's nice.
Are you saying I've got a chance?
So far, so good. Are we all good so far? Do I need to pause, answer questions?
Yeah, I think we're good.
Great. Moving on. All right. So we turn our attention to the First Circuit case that is the best for this situation for Karen Reed. This was a case in which a jury, incidentally, a federal jury in this case, which is interesting because the federal court is obviously in direct review of a federal court, and this is a collateral attack. So that different posture may play into this situation, but we'll take it for what it's worth. This case from the First Circuit, this is actually, we'll start with the U.S. Supreme Court first before we go to the First Circuit, so we can talk about the Supreme Court decision first. So this is from a Supreme Court case called Vernico versus Lett, U.S. Supreme Court 2010. So this is what the U.S. Supreme Court had to say about the issue of mistrials. Trial judges may declare a mistrial when, in their opinion, taking all circumstances into consideration, there is a manifest necessity for doing so, that is, a high degree of necessity. The decision to grant a mistrial is reserved to broad discretion of the trial judge, and discretion to declare a mistrial for a deadlocking jury is accorded great deference by a reviewing court. Abuse of discretion analysis, which is very difficult, right? Trial judges get a lot of latitude in terms of what kind of proceedings they run, what kind of timeframes they run, even what witnesses are allowed to testify, relating to ARCA to some degree. I'm sure we'll get into that a little bit more, what they can testify about, what not, what order they can testify, and so forth and so on. So they get a lot of latitude to run their courtroom. So it's an abuse of discretion analysis. The Supreme Court continues to write, this court has expressly declined to require mechanical application of any rigid formula, which means that there is no set rule. There's nothing I can say that it's like, oh, it's A, B, C, and therefore whatever, right? There is no mechanical rule. So it's all a little floaty, which sometimes we have in law, and that's the situation. But the Supreme Court continues to write that a judge is not necessarily required to make explicit findings of manifest necessity or articulate on the record the factors for their reason. So they don't have to tell you why they did it. They don't have to mention it. And the court has also never required a judge in these circumstances to force a jury to deliberate for a minimum period of time, to question the jurors individually, to consult with the attorneys, to issue supplemental jury instructions, or consider any other particular means of an impasse. So that, again, there is no particular thing, at least the Supreme Court says, that a court is necessarily required to do before it can declare mistrial. So do they have to talk to the attorneys? Not necessarily, they don't, says the U.S. Supreme Court. So there is no dispositive element as far as the U.S. Supreme Court is concerned. Okay, cool. So with that in place, we turn our attention now to this First Circuit case, which is trying to clarify this issue a little bit more as a matter of the First Circuit, where, of course, Massachusetts is. And this is a case of U.S. versus Torbillo-Lugo, U.S. Court of Appeals, First Circuit 2004. And so they're going to discuss two issues here, both of which are relevant to our immediate issue. So the first issue is the issue of manifest necessity. It is not double jeopardy if we're having another trial due to manifest necessity. All right, this is well established. If there's manifest necessity, we can have a second trial. Cool. All right, so when do we have manifest necessity? How do we know if we have it? Well, the First Circuit, like the US Supreme Court, says experience teaches us there is no mechanical rule for determining whether a mistrial is supported by manifest necessity. So the First Circuit basically is like, look, we've tried, the US Supreme Court has tried, no one is able to find a mechanical rule. No one can say A plus B plus C. There's merely some indicia and there's some guidelines that are kind of floating out in the ether. And maybe if these things, but maybe not these things, right?
Yeah, I guess it's subjective.
Well, I don't know if it's necessarily subjective. It's a little bit floaty, but either way.
Yeah.
So the First Circuit continues to write that typically the inquiry is informed by a triumvirate of interrelated factors. So these are some things that you may consider along the way, but of course are not dispositive, because if they were dispositive, that would mean there's a mechanical rule, which of course there's not, because they just told you. But here's some factors you might want to consider. Whether alternatives to a mistrial were explored and exhausted, whether counsel had an opportunity to be heard, and whether the judge's decision was made after sufficient recollection. Now, to my mind, those factors seem to lean more in the favor of Karen Reed than they do the Commonwealth. It's not necessarily clear that alternatives to a mistrial were really explored. It's not really clear that counsel potentially had an opportunity to be heard. And it's not necessarily clear the judge made sufficient reflections. So those factors seem
Let's go with no, and no. Yeah.
Seem potentially positive for Karen Reed. So that's good news. In the case of the First Circuit, they write that the district court in that situation only tentatively explored and never exhausted the possibility of, in that case, proceeding with an 11-member jury, which is allowed under the federal rules. You can proceed with an 11-member jury if there's consent, but they never really gave sufficient consideration.
Right.
Instead, the court mistakenly concluded the alternative was foreclosed by the defendant's initial expression of preference to wait to see. So initially, the 12th member was just kind of missing. We're not quite sure where they are, and they're like, can we find the 12th juror? And then at a later point, which I find kind of hilarious, at a later point, the court figured out that actually that juror has been missing for the last 4 days, and we're just now noticing.
The juror did show up and nobody knew?
I mean, apparently we didn't notice there were only 11 members in the jury box for 4 days. How exciting.
Oh,
our ability to count leaves something to be desired, but that's okay. Pressing on. So anyways, when there's a viable alternative to a mistrial and the district court or trial court fails to adequately explore it, a finding of manifest necessity cannot stand. So there is this idea that, there was never really, of course, any explicit discussion of polling the jury. There was never really any explicit discussion of partial verdicts. There was never even really explicit discussion of asking the jury for consent to continue. Now, that consideration could have taken all of like a half second, right? The judge could have just been like, well, I know the rules allow for it, but I'm not going to do it. But that might be sufficient consideration. But the fact she didn't even say that much is a bit problematic for the Commonwealth. Where things get better for the Commonwealth in terms of their ability to have this not be a habeas issue is this issue of consent, or if you prefer, waiver, which I think is slightly less inflammatory. This is a more generalized concept. If you don't raise an objection, you lose it. You got to raise contemporaneous objections.
Use it or lose it. Smoke them if you got them.
Use it or you lose it. So they call it consent. We could call it waiver, but either way, it kind of amounts to the same thing, right? So
I'm sorry to interrupt you for 1 second, but the chat is going off.
Please take your time.
The unredacted, the redacted copy of the motion to dismiss has been docketed in the court. Christina Rex has tweeted that she has a copy of it. It's 147 pages. Doesn't mean it's scanned into the system yet. As soon as I get a copy of it, yes, we will read it cold. All 147 pages of it. So never fear, I'm on top of it. So let's let Kurt continue to talk. Okay.
All right,
just because Christina Rex has it doesn't mean she got it from the court docket. She may have had a leak. All right, move on. Thanks.
No worries. So this issue of did Karen Reed consent to the mistrial is for my money her biggest problem in the habeas review.
Okay.
So the court in this First Circuit precedent notes that requisite consent may be implied from defendant's acts or failure to act, such as where a defendant sits silently by and does not object to declaration of mistrial, even though they have a fair opportunity to do so. So the failure to object could be deemed consent or waiver if you prefer that language. The district court has also held, or that case, the district court held that the implied consent to declaration of mistrial by silence while the court announced its intention to abort. And so that is kind of sort of applicable to this situation, right? The judge is saying, I'm going to declare a mistrial, but the defense lawyers aren't doing anything. You know, the judge has announced their intent, you know, let's bring in the jury, but they're not saying, you know, we object, we want to be heard. They're not saying anything like that. They're just kind of sitting on a log. So
and they're no shrinking violets, as you know.
Yeah,
they are not shrinking violets.
So that's a bit problematic. The First Circuit continues to write, implying consent from failure to object requires at a bare minimum, defendant had adequate opportunity to register an effective objection. And then they compare some cases which sort of lay out some guidelines or points of comparison. They say, compare one case where defense counsel sat in a courtroom for several minutes during the announcement of a mistrial without objecting. And then compare another case in which they rejected a finding of implied consent, where in that case, the trial judge, in a state of grief after learning of the death of his family, abruptly ordered a mistrial and left the bench. So the judge is just like, my family's dead, I'm ordering a mistrial, and just like left the building. You know, Elvis has left the building, so there's no opportunity to object. Right. And so thus the question reduces to whether defense counsel had a fair opportunity to object. So which of these kind of universes are we in? And for my money, at least, I think that we're closer to the universe where she had a fair opportunity to object. She had at least the 30 seconds when the jury was being brought in. And of course, since the jury wasn't, you know, dismissed, go home, they were sitting in a back room waiting for the judge to give them their exit instructions. You know, at least hypothetically, we could have gone and got them. They're right over there, right? If we needed to do something. So I think the failure to object, at least during the 30 seconds and potentially during the, you know, rescheduling conference that preceded the dismissal of the jury, I think might be sufficient opportunity to object. So I think that on balance, taking all these factors into consideration, you know, between abstention, like will the court even hear the case at all, which is still a factor, and given the state of the case law on this point, what is the probability that if they decide to hear the case, that they'll rule in favor of Karen? It's like, for my money, I think she has a chance, but I don't think it's a particularly great one. You know, maybe it's 1 in 5, and something like that, maybe.
But these factors are all the same factors that they heard in state court, right? The manifest necessity, the opportunity to be heard, the consent. Those are all the same issue. Like, there's no different issues here. It's just a matter, I guess, of whether they are going to see it differently than the SJC saw it. Yeah.
Well, yeah, that's true to some degree, but of course we're in a federal habeas proceeding, and so while the state Supreme Court, of course, is sworn to obey the Constitution, and one would hope they're doing their best, in the end, of course, the federal court is the ultimate judge of federal law, and this is a de novo review, of course, as to the federal law. So they do have to accept all the facts of the Supreme Judicial Court. So, for example, when the Supreme Judicial Court said that the trial judge did do sufficient consideration of the case, and there was sufficient review, that might be a fact that the district court for the federal court is now stuck with. So they, for example, they might not even be able to get to this manifest necessity, because again, remember in this First Circuit case that we're reviewing, it was an appeal from a U.S. district judge. So we didn't have like those problems, right? The Court of Appeals can just be like, I'm reviewing you because you're a federal judge. I'm a federal judge. You're a federal judge. I'm your boss. So I get to review your work, you know? But the federal court is not the boss of the state Supreme Court. They're not the boss of the state. So the state Supreme Court saying, well, the judge gave sufficient consideration, she did pursue her options, that might be a finding of fact, not a finding of law. And if it is a finding of fact, the district court is bound by it, which means that the probability of even finding manifest necessity now has to be reduced.
You know, I see people in the chat saying that, you know, it's on the defense, they should have objected. Here's the thing. If you're a defense attorney, and you're looking at the chance of, you know, a mistrial, which is, okay, we're out of here, she's not going away in handcuffs and being hauled into prison. Or you're saying, you know, let's poll the jury and find out what they did on each count. You run the risk that they're going to come back and say, oh, yeah, well, we actually did convict her on one of them, but not all of them. And so then she's walking away in handcuffs. Like, as a defense attorney, what are you going to do? I don't fault the defense for not making a big stink in those 30 seconds. So I think that perhaps the judicial handbook of Massachusetts should be revised so that it is up to the judge when there are multiple counts to inquire, have you reached, because she told them, don't come back to me with those forms filled out until you have reached a consensus on every single count. And there were 3 verdict sheets.
Yeah. And as to the state level rules, only the Supreme Court of Massachusetts can judge those state level rules. The federal courts have no power to reinterpret the state level law. They can only take it as a given and then say, given that state level law, there's a conflict with the federal law, which of course the federal courts are empowered to decide. So for example, like, what does the rule mean with respect to partial verdicts? That's a state level rule. So it's up to the state Supreme Court. What form does the verdict has to take? Well, it's a state level rule. It's up to the state courts, and so forth and so on. Can the judge insist on complete verdicts? Can a judge say this is all or nothing? It's a state level rule. I don't know of any federal law that says that you have to have partial verdicts. You know, if that decision existed, presumably one would cite it. So can a judge say, I'm going to insist on all or nothing, all verdicts or none? It's like, yeah, I think they can, as far as I can determine. Right. So, and there is that one case, Bluford, which seems to strongly suggest that possibility, which was U.S. Supreme Court. In Bluford, U.S. Supreme Court, in that case, that was a murder trial. The jury came back, said, we're not guilty as to the murder count, but we're not quite sure as to the other counts. And so the judge said, try harder, gave him the instruction, try harder. The jury went back and deliberated for a while. And then the jury said, well, now we can't figure it out. Now we don't know. Now we don't have any verdicts on anything. And the U.S. Supreme Court said that was okay. Right. It says, like, so it's like, well, it seems like partial verdicts aren't required. So the judge doesn't seem to abuse their discretion on insisting on it. Incidentally, I think it will be really interesting in the retrial if, when they're discussing the new jury instructions, whether the defense, insists on partial verdicts. Right. I somewhat don't think they're going to do it. Because of course in the new trial they have no idea what the new jury is going to think, right? It's worthy of noting, by the way, of course, this petition is so emphatic because they know the answer now, right? They know the answer now. Like, if the judge had come back to, we'll never know for sure because we can't do the counterfactual. But if the judge had come back and be like, hey, defense, do you want partial verdicts in that first case? I don't think the defense would have done it. And I don't think they're going to do it in the new case. They say they want it now because they know the answer now. Yeah,
hindsight is always 20/20, right?
But that's cheating.
But when you're in the moment, you're thinking, all right, we got a mistrial. It's not a conviction. She's not heading off to the pokey. So win-win. Let's get out of here. Leave skid marks. That's what I would do. Yeah. I don't know that I would risk her going back there and talking to them. And I don't know.
Yeah. So that's all I had on the issue relating to the federal habeas. And then I had one other case that you actually brought to my attention relating to an issue which is not currently presented. Yes. But an issue relating to who was guarding the jury.
Yes. Who was guarding the hen house, the fox?
Who was guarding the jury? So apparently the judge decided, I was going to share this case.
Oh, good.
Talk about this issue. So this is not in the habeas, but this is an issue that's lurking somewhere in the background. So as we've learned, the person that was put in charge of the jury was Michael Proctor's boss, which seems deeply questionable. Deeply questionable. This is the person that welcomes the jury into the jury room at the end of the day, in the start of the day, and maybe takes them to the car and escorts them to the cafeteria and so forth and so on. Michael Proctor's boss is going to be the person to sit outside and guard the jury. How exciting.
Yes. Lieutenant John Fanning is his name, folks. And you may remember him from such things as being part of those gross text messages that Proctor was sending to to his boss, Fanning and Buchanan and others about, I'm just sitting here looking for nudes in Karen Reed's phone. And then after the trial was over, Fanning did face some internal affairs repercussions for not properly chastising him or disciplining Proctor for those messages because he said he was on vacation and he never saw the messages. And so he got, off scot-free. But apparently Alan Jackson said it in an interview with Ted Daniel. And I think it's going to be part of this motion that when we get a copy of it will be redacted. But that's probably going to be part of their argument to dismiss based on the fact that there was an extreme conflict of interest with regard to who it was that was in charge of the jury.
And to that point, we take our attention to Turner versus Louisiana, U.S. Supreme Court in 1965. Long story short, we've got some witnesses in the case who are police officers who are guarding the jury. So it's one step worse. It's one step worse than we got actual witnesses in the actual case who are police officers who are also going to guard the jury while they're doing deliberations. That's super exciting.
Well, but here's the thing. So Fanning, I don't know if he was on either witness list of the Commonwealth or the defense. He was never called, and I'm not sure if he was on, but the jury has to be guarded throughout the whole entire trial. What if he was on the witness list for the Commonwealth?
Yeah. He might have been on the witness list, so maybe he's witness enough for the purpose of this analysis. But either way, I'll just go to the punchline here by the U.S. Supreme Court. The punchline is it would have undermined basic guarantees of trial by jury to permit this kind of association between the jurors and two key prosecution witnesses who were not deputy sheriffs. So if these people were not sheriffs, if they were just like other witnesses that were somehow conscripted into this role for some reason, right, that would be problem enough. But the fact that they're sheriffs, of course, makes it worse. The role that Simmons and Rispone played as deputies made the association even more prejudicial than just some other random witness. So the fact that it's the government makes it even more prejudicial. For their relationship was one that could not foster jury confidence in those who were official guardians during the entire 2 weeks of the trial. And the fate depended on the confidence of the witnesses. And so the Supreme Court even said basically at that point, this is so bad, the defense doesn't even have to show specific prejudice. Right? This is such a bad thing that the defense doesn't even have to make a finding of prejudice. It just is prejudice. Please stop doing this.
Automatic prejudice.
And it seems like the judge went out of her way to assign this role, which raises all kinds of fun and interesting questions relating to potential immunity.
Yes, judicial immunity. Aren't you glad I sent you down that rabbit hole?
Yeah, those are all the things. So there is some potential, hypothetically, that she might not necessarily be immune in some sort of proceeding relating to this because it might not necessarily relate to her judicial role as such. But that's a whole nother discussion for another stream that you might have to bring me on. Ooh,
all right. Well, I am in possession right now of the redacted version of the motion to dismiss for extraordinary governmental misconduct. Who wants to hear it?
I'd love to hear it.
Anyone?
Let's go.
All right, let's go. Let's go. We're here for it. Thanks, you guys. Thank you to my special friend who sent it to me. It has been redacted, allegedly. This is the redacted version. It is, well, I don't know why she said it was 147. I have 36 pages. Hold on. Let me just...
Maybe the unredacted version is shorter.
Maybe could be, or there could be exhibits.
Maybe there's 111 pages of rejections. That'd be good.
Yeah, there could be exhibits, actually, after this. All right, here we go. Here we go, my friends. Look at you wrapping it up right in time, right in time.
I do what I can.
I know, you're the best. Here we go. This is docket number 521, docket number 521. Defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. I like to get my red pen ready because, girl's got to have her red pen. I like how it has a
redacted version written in pen. That's cute.
Yeah, exactly. 521. Let's hear about all the extraordinary governmental misconduct that we can find that is not actually redacted. Ready, set, share it out, you guys. Get everybody over here. Put it out on the cesspool of Twitter if you so choose, because I don't play over there, as you know. Save your questions because I can't read the chat while I'm reading to you. And let me know, Kurt, if you would like me to stop at any time. Now comes the defendant, Karen Reed, Ms. Reed, and respectfully moves this honorable court, pursuant to Article 12 of the Massachusetts Declaration of Rights, the 5th, 6th, and 14th Amendments to the U.S. Constitution, and Massachusetts Rule of Criminal Procedure 14C, to dismiss all charges with prejudice on the basis of extraordinary governmental misconduct. See U.S. Constitution, Fifth Amendment, U.S. Constitution, Sixth Amendment, and the 14th Amendment, Article 12 of the Declaration of Rights of the Massachusetts Constitution, and Rule 14, which we've become way too familiar with. A prosecutor, quote, may strike hard blows, but he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. Citing Berger versus the United States. Throughout the course of these proceedings, Ms. Reed has been severely prejudiced. I knew that was going to happen. By the Commonwealth's pervasive misconduct. The Commonwealth has suppressed discoverable and exculpatory video surveillance footage from the Canton PD. It has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started, and after the Commonwealth represented that all video footage had been provided to the defense. For reasons that remain unexplained, much of the video has been disclosed. Much of the video that has been disclosed is, quote, missing, end quote, critical timeframes and evidence central to Ms. Reed's defense. Some of the video clearly appears altered or manipulated, as evidenced by people appearing and disappearing out of nowhere. Remember that ghostly video? At the first trial in this matter, Assistant District Attorney Adam Lally, ADA Lally, brazenly introduced inverted video and elicited patently false testimony from MSP Sergeant Yuri Buchanek that the video was a fair and accurate depiction of critical events in an attempt to falsely insinuate to the jury that no member of law enforcement ever approached, touched, or otherwise disturbed the right rear tail light of Ms. Reed's SUV. I remember screaming when that video was shown in court. How did it get here? How did nobody catch
how did a lot of evidence get here with missing logs and a lot of it? I have authentication questions for many things.
Oh, and she just denied the motion where they're asking for evidence, chain of custody logs and metadata, and she denied it.
Of course she did. That's
no
fine.
metadata for you.
That's fine.
Where was I? There can be no doubt. There can be no doubt that this video and false testimony was offered to mislead this court, the jury, and the defense by making it appear that MSP Trooper Michael Proctor, Trooper Proctor, was standing next to the left rear tail light when the Commonwealth knew the exact opposite was true. Trooper Proctor was, in fact, standing directly next to the right rear tail light. I wish they would say driver's side and passenger side, but nobody asked me. It just makes it easier, I think. Other Sally Port video, which was unquestionably favorable to the defense because it would have severely discredited key witness Brian Higgins. What did you call him? A beta? He was a beta male. You had a good nickname for him. Blankety blank blank blank, which we don't know, redacted, inexplicably was not disclosed to the defense until months after the first trial. That may say talking on the phone outside of Canton PD at 1:34 a.m. because they did turn that video over, but we already know that, so it may not be that. To this day, the Commonwealth's failure to explain the disturbing circumstances surrounding their disclosure of the exculpatory Sally Port video and why some video was suppressed from the defense at the first trial has made a mockery of Ms. Reed's right to due process. Commonwealth exploited this court's order instructing the defense to disclose its impeachment material in advance of witnesses testifying. And again, she just ruled that they have to turn that stuff over again, which is wild to me because that would never fly in New York. It's like, hey, let's take away your smoking gun so that we can prep our witnesses on your smoking gun, and then they can have a whole story about why your impeachment evidence isn't really real or whatever. ADA Lally and MSP Lieutenant Brian Tully huddled with key witnesses Jennifer McCabe mid-trial. Ooh, really? That's not good. Prepped her on how to explain why she never disclosed that she went to Canton PD Sergeant Michael Lank's house one day after John O'Keefe's death, and then suppressed exculpatory statements made by McCabe during that session until nearly a month after McCabe's testimony at which point McCabe and other relevant witnesses were safely off the witness stand. I'm sorry, what? You don't seem shocked. If
Par
the
for
Commonwealth had
course.
complied, what?
Par for course.
If the Commonwealth had complied with their obligation to provide statements of witnesses before they testify, the defense would have been positioned to expose McCabe's material, inconsistent statements about her meeting with Sergeant Lank. And they don't turn it over until after she testifies. And they're squawking and screaming and crying and stomping their feet about the fact that Alan Jackson didn't turn over an email that he got from Daniel Wolf on a Sunday, the day before he testified, where he gave him like some direct examination questions Wolf gave to Alan Jackson about his pedigree. Really? Okay. This entire portion of the rest of this page is blacked out, as you see, because they don't want us to know. And that's we're on page 3. As a result of this extraordinary governmental misconduct, Ms. Reed has been permanently and irreversibly denied her constitutional right to a fair trial. No remedy other than dismissal can adequately address the significant harm caused to Ms. Reed and the injustice of proceeding without the lost exculpatory evidence that was in the Commonwealth's possession. And there's a whole maybe 3 or 4 sentences that are blacked out. Accordingly, the case against Ms. Reed must be dismissed with prejudice. That's what they want, and that's a severe remedy, but it may be warranted. Statement of facts. This is Roman numeral 1. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe: murder in the second degree, manslaughter while under the influence of alcohol, and leaving the scene of personal injury and death. Period. A months-long jury trial was held in this matter beginning on April 17th, 2024. On June 25th, 2024, the jury began deliberations. After the jury submitted a note to the court indicating that the jury was at an impasse, the court declared a mistrial on July 1st, 2024. We go to footnote 1, which says, in the days and weeks following the first trial, 5 deliberating jurors have come forward and indicated that they had unanimously acquitted Ms. Reed on counts 1 and 3 and were hung only with respect to count 2. They indicated that they did not believe they were permitted to report the unanimous decisions on count 1 and 3 unless they were able to reach a unanimous verdict on all counts. Ms. Reed's failure to address any claims of double jeopardy in the instant motion to dismiss shall not in any way be deemed or construed a waiver of those issues which are presently pending before the U.S. District Court for the District of Massachusetts.
Smart to say that. Very
Yeah.
smart to say it.
Yeah, just because we're not bringing it up now doesn't mean we waived it. We're up on appeal, and it's in federal court. And for those of you just joining, welcome. We did cover that right before we got our hands on this motion to dismiss. So if you are just joining, you may want to rewatch that part later. We got Kurt's take on the federal appeal. The Commonwealth altered the course of the first trial in this case by destroying exculpatory evidence, withholding exculpatory evidence, and interfering with the jury. Oh, it's coming. Here it comes. The interfering with the jury.
Let's go.
I told you.
Let's go.
Told you I had a feeling. In a case in which the jury either voted to acquit or was deadlocked on a lesser of one charge. There is no cure short of dismissal with prejudice that can remedy the serious constitutional and statutory violations that have occurred in this case. The facts relating to the respective misconduct and discovery violations are set forth below. Paragraph A. Facts relating to the destruction and withholding of exculpatory Canton PD video surveillance footage. This court is aware of the critical importance of the video surveillance footage from the Canton PD on January 29th of 2022. The Commonwealth has produced dribs and drabs, I think they stole that from me, just kidding, of various clips of video surveillance obtained from the Canton PD's ExacuVision DVR system from January 29th, 2022, without any accompanying reports, evidence logs, or other documentation regarding the recovery and chain of custody of this evidence on at least 4 separate occasions. And I only say that because dribs and drabs is typically not one of the big SAT words that Alessi would use. It's something that I would say. All right, moving on. 1, relevant discovery orders. On February 2nd, 2022, the defense filed defendant's emergency motion for preservation of evidence. And this, remember, this is when Karen Read was first arrested and arraigned in Stoughton District Court, February 2nd of 2022. And that was when David Yannetti represented her. We recently rewatched the video of that arraignment hearing. And it was interesting because we heard him say this on the record, including the preservation of all physical evidence, such as video surveillance footage with the Stoughton District Court, Exhibit A. February 2nd, 2022, order on motion to preserve evidence. At the February 2nd, 2022 hearing, ADA Lally stated in open court that he had reviewed the proposed order and had no objection to it. That same day, the district court issued a preservation order for all physical evidence, which includes video surveillance footage. In other words, 3 days after O'Keefe's death, the Commonwealth was aware of its affirmative obligation to preserve any and all video surveillance footage in its possession, custody, or control, which included the Canton PD and or MSP, and ADA Lally was required to notify law enforcement of this order. And you know, we watched this hearing together. I'm breaking for a second to say, and we heard the judge say in open court, well, of course, it's obvious, but I'll sign your motion. I'll sign the order anyway. And he said that. And it's so obvious. You shouldn't have to say this. They are under an affirmative duty, the prosecution, right?
Very much so, yes.
Your head might pop off today too.
Yeah.
It's basic.
Brady, Giglio.
Yeah. It's like we shouldn't have to tell you to do this. You know, and so when Brennan gets up in open court and says, well, they didn't specifically tell us that we had to do this, or, you know, why should we have to, it overwrites itself within 30 days. No big whoop. No metadata, click and drag. It's not a big deal. Click and drag it. It's on some retired detective's computer now. Is wild to me. We're in the upside down, the Matrix, Narnia. We are so far into it and we can't dig out. On September 16th, 2022, after Ms. Reed's case was transferred to Norfolk Superior Court, because following her June 9th, 2022 indictment, that is when they upgraded her to murder charges, if you know, you know, the defense filed a separate motion to compel the production of certain outstanding discovery, quote, including all crime scene photographs and or videos taken in connection with this case. See Exhibit B. Okay, so that's 2. That's 2 times that they've asked. October 5, 2022 order on defendant's motion to compel. On October 5, 2022, this court granted the motion to compel in part and ordered that the Commonwealth produce all video evidence and metadata associated with the videos on that date. That is within 1 year. That is October 2022. Metadata. Don't care about metadata. 2, dates of production and facts relating to discovery and constitutional violations. The Canton PD's video surveillance footage has been in the Commonwealth's possession, custody, and control since January 29th of 2022. Some more redactions. All the way. A whole bunch of things that we can't read, although maybe I don't even want to hypothesize, but it's pretty bad if it's redacted, because that wouldn't be under a federal protective order. That stuff, that's all stuff that was in Canton PD's custody and control. So I don't think, unless the feds found out about it, right? And then they had that information and that's how they got it. I don't know. Notwithstanding this court's October 5th, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, the Commonwealth and its agents withheld this exculpatory evidence from the defense for more than 2 years, failing to disclose even the first incomplete batch of footage until the eve of the first trial on April 4th, 2024. Footnote 2. Oh, I think I know what's redacted here. Alan Jackson said in open court recently that they just came into possession, like within weeks from today, of Karen Reed's Lexus being backed into the Sally Port garage. from an exterior camera at the Canton Sallyport. I was screaming, it's got to show her taillight. If the car's backing into the Sallyport, and remember, Kurt, when we saw the inverted video, that Lexus pulled into a snow outline. Remember, there was snow on the ground, and I'm thinking, they said they had to tow it to Canton PD because it was heated, that Sallyport. Why is there snow on the ground? And so many of you guys in the chat were screaming, they must have moved her car in and then moved it out and then moved it back in again. Well, all of a sudden, it has revealed itself that there is video of Karen Reed's Lexus backing into the Sallyport. They just turned it over. If my best guess would
just
be
now,
that is
huh?
Yeah, just now, within the past 2 weeks or so.
I love how we keep discovering all this new and exciting exculpatory evidence.
Yeah, and Alan Jackson said it's exculpatory. They have just now provided
One would
us.
think.
Yeah.
Maybe that's where the damage to the taillight come from. Could be that too.
Yeah. From backing into the Sallyport?
But I'm sure it's that the prosecution had no idea this evidence existed, and it's just their due diligence. They're really just fine-tooth combing every grain of sand, and they found this video that was in a dustbin somewhere. Right. That's it.
Right. Brendan's going to take credit and be like, I unearthed this. Here I am. I'm the new guy in town at $250 an hour, and I'm going to come in here and I found it, and I'm going to turn it over to you because I'm a great guy.
The only thing else that could surprise me at this point is when they turn over the disclosure of the confession from the real murderer.
Yeah. Or the video of the actual incident of the death of John O'Keefe. Right?
Those things, yeah.
Because, they told mainstream media there was video, ring camera footage of Karen hitting John with her car on the day of the event, and they ran with it. It's still out there. They've never retracted it. We never saw that ring video because it doesn't exist. Notwithstanding this court's order, October 5, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, the Commonwealth and its agents withheld this exculpatory evidence from the defense for more than 2 years. I already read that part, and did we read the footnote? Well, the footnote has been redacted, so it doesn't matter. The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage recorded at the Canton PD on January 29th of 2022. So all they had to do was preserve 24 hours worth of footage, and they couldn't even do that. April 4th, 2024 production. On April 4th, 2024, on the eve of the first trial in this matter, the Commonwealth, for the first time, disclosed woefully incomplete Canton PD video footage, which consisted of video from the Canton PD main driveway and Canton PD Sallyport front wall cameras from January 29, 2022. Curiously, the Sallyport front wall footage omitted a 42-minute interval at the precise time the SUV arrived at the Sallyport garage. See Exhibit D.
The missing 42 minutes, man.
Mm-hmm. Yeah. And see Exhibit D and Exhibit E. They've got receipts. The missing footage from the Sallyport front wall camera would have captured a close-up of the condition of the SUV's right rear taillight upon arrival at the Canton PD Sallyport garage, B, the individuals who had access to the right rear taillight, and C, whether anyone removed taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road. The condition of the right rear taillight of the Lexus SUV at the time it entered law enforcement's custody is perhaps the most critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Sallyport front wall camera footage. Moreover, the data was not preserved in a forensically sound way, in violation of the February 2, 2022 preservation order, which means that the defense had been denied the ability to determine whether the Commonwealth deleted, altered, or manipulated, or otherwise lost critical video evidence in its possession that it was obligated to preserve. It's also basic.
Sometimes with this case, it's like it's my first police investigation. They made so many mistakes between labeling and logs and handling of evidence, and it's just floating around in the trunk of some person's car for a while, and missing video, and so many things. Is it my first police investigation?
Well, do they want you to believe that they're incompetent or corrupt? It's like spin the wheel. Which one is it? Neither is good, but we know, because I've been over with you guys in the chat, other investigations by these same officers as such in the Brian Walsh case, the Ingolf Turk case, all in the same county. And they know how to do an investigation. They know how to do a 36-page police report. The Canton PD does, or was it the MSP? I forget now, on Richard Schiffer, who put little rubber ducks this big all around town that had Colin Did It stickers on the bottom of it. They were charging him with witness felony intimidation, and they did a 36-page police report and pulled video camera footage of him driving by in the area where the ducks were found. They went to his house. They did a trash pull to find envelopes of where he got those stickers. They went to his work and put the text stream data into his truck to pull all of his GPS to prove that he was in the area where these ducks were found. So they do know how to do it. All those charges were dropped, by the way. That's the rubber ducky case. B, April 10th, 2024, the Commonwealth files its certificate of compliance. On April 10th of 2024, the Commonwealth filed a certificate of compliance in which ADA Lally certified to this court 6 days before trial that the Commonwealth, after exercising reasonable inquiry and due diligence to the best of their ability, disclosed and made available all items subject to discovery. Exhibit F. April 10, 2024, certificate of compliant, emphasis added. This representation was patently false. It strains credulity. It strains credulity. I have merch, you guys. I have merch. It's a little wink and a nod to me, maybe. That ADA Lally, in light of his actual knowledge about the preservation order and existence of extensive Sallyport video, would represent to the court and to the defense that after reasonable inquiry, he disclosed and made available all known discoverable material in his possession, custody, and control. At a minimum, rather than mislead the court and the defense, ADA Lally was obligated to inform the court and the defense that there was outstanding video surveillance. See Massachusetts Rule of Criminal Procedure. Oh, no, I'm sorry. Massachusetts Rules of Professional Conduct. Now we're getting into Ethics 3.4D. And footnote 3 says, ADA Lally was cognizant of other discoverable material that the Commonwealth did not disclose before certifying his compliance with his discovery obligations. Notably, when filing the certificate of compliance, he expressly represented that the, quote, lone exception of outstanding discoverable material was some evidence related to the DNA testing and analysis. See Exhibit F.
Mm-hmm.
Massachusetts Rule of Professional Conduct 3.4D says, party may not fail to make a reasonably diligent effort to comply with a legally proper discovery request. C, April 23rd, 2024, the Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear taillight of Ms. Reed's SUV.
Defraud is an awfully aggressive word choice.
I love it. I mean, but really, wasn't it? Because I remember Buchanan testifying about this, and it wasn't until cross, and there was a break in between. It was like he did direct, and then there was either a day off or a weekend. Then he was brought back where he had another full day to be maybe prepped again. And it wasn't until cross that it was brought out that it was inverted. And he said, well, yeah, I mean, you know, it's like a mirror, you know, like you're looking at your reflection, but everything's just like, you know, it's the same, but it's just, you know, inverted. Am I putting you to sleep?
No, that's all right. I'm good. You're fine.
Okay. If you need to go, you can go.
No, I'm fine.
Okay. Everything from there is redacted to the bottom of the page. We're on page 8, and then redacted for the first paragraph of page 9. Sorry. On April 23rd, 2024, the Commonwealth produced additional footage from the Canton PD Sallyport back wall via a share link entitled Additional Sallyport Video Download Link. April 23rd. Footnote 4. No flash drive was presented to the defense. Okay. Exhibit 8. H. Inverted Sallyport video. I think that says footnote 4. The Commonwealth never filed a supplemental certificate of compliance. Why should they? He was like a one-man band. I mean, you know, he really didn't have any help. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury that nobody approached or touched the right rear taillight of Ms. Reed's vehicle after it entered the Sallyport. ADA Lally craftily elicited testimony. That's generous, don't you think? Craftily elicited testimony from Sergeant Buchanan that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV when it arrived at the Canton PD on January 29th, 2022. And that, quote, as seen in the video, end quote, no law enforcement officer approached the right rear tail light. Here's the transcript to prove it. Exhibit I and Exhibit J. I think I would have chosen a different word for craftily. I would have maybe said underhandedly. That might have been. Can you think of another word that you would have chosen?
Deceptively.
Mm-hmm. I'll allow it. On cross-examination, however, Sergeant Buchanan's testimony was exposed as profoundly misleading at best and perjurious at worst. It's being kind also. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality. Critical facts, which neither ADA Lally nor Sergeant Buchanan saw fit to inform the court, defense, or jury. Like I just said, and this is a cold read, as you know, because we just got this out off the press. In other words, this video made the left side of Miss Reed's SUV appear to be the right, and the right appear to be the left. Am I right side up or upside down? Therefore, the video presented to the jury as, quote, fair and accurate, end quote, appeared to show a person, Trooper Proctor, standing near the left rear taillight of the vehicle, when in fact, Trooper Proctor was standing near the right rear taillight, i.e. the taillight at issue.
I mean, to be fair, I suppose, to the prosecution and the police, everything else is backwards in this case. So maybe from their point of view, inverted is fair and accurate representation.
Right.
That's just how they see the world.
Yeah, except for all the other video from that camera from inside the Sallyport wasn't, right? But yeah, it's all backwards and upside down and inverted. The truth is what's inverted here. John O'Keefe did not get hit by a car. A car did not hit John O'Keefe. Today is February 27th, 2024. And like my mug says, Karen Reed was still framed.
I don't know whether she's framed, and to some degree, I don't have to care, right? Within the confines of the case, all I have to determine is whether the state proved it beyond a reasonable doubt. And to that, I can just say, lol, no. Do I know what happened? Not really, but she's innocent. She's not guilty. So that's all I need to know. So I'm good.
But once they decide to pin it on the girl, I'm going to call that framing. I mean,
fair enough.
You know what I mean? Like he wasn't hit by a car and a car didn't hit him. And, you really don't need a degree in biomechanical engineering to come to that pretty common sense conclusion.
Yeah, I also am not sure I needed a degree to know that you might hit more pedestrians at night when it's dark outside and harder to see them.
Because, luminescence or
luminescence,
something.
Yeah.
Yeah, and by the way, I have that pulled up because we were going to do that until this came out. It was to look at the voir dire of those ARCA experts from the first trial. And it was all clearly brought out during the voir dire.
If the defense loses the ARCA experts, I'd like to volunteer myself. I'm at least as qualified as Trooper Paul. So I'm able to testify expert opinions, no problem.
But do crime scenes speak to you? Because that seems to be a requirement.
So many things speak to me.
The voices in your head. I think Trooper Paul might have some voices in his head, and maybe he sees dead people. I don't know. Moreover, the inverted video does not capture the condition of the right rear taillight, and it conceals Trooper Proctor's presence by the right rear taillight. This leads to the inescapable conclusion that ADA Lally's questions, Sergeant Buchanan's responses, and the deliberate introduction of inaccurate evidence was designed to perpetrate a fraud on the court, the jury, and Ms. Reed with respect to a critical issue in the case. And that, my friends, is an actual ethical violation if you perpetrate a fraud on the court and it can be proven that you did that knowingly. So Mr. Lally might have he might be called as a witness. D, on October 10th of 2024, the Commonwealth produces additional exculpatory video surveillance footage in violation of Brady and Rule 14. This is, way after the trial ended.
That's amazing. All this new wonderful disclosure of material, new disclosures every day. How fun.
Maybe the camera spoke to Trooper Paul and said, hey, Trooper Paul, I got some more video footage for you. Hey, Colleen Crawford, the person who's in charge of all the forensics for, the DA's office and the I don't know, Canton PD. Maybe it was just unearthed. It just revealed itself all of a sudden. This time from the Canton PD church side exterior, first floor corridor, rear lot main side, and rear lot cruiser side cameras. Wow. There's 1, 2, 3, 4 new cameras with new video that just unearthed itself magically. This footage shows Higgins arrive in the parking lot of the Canton PD at 1:26 a.m., enter the building, and speak to some unidentified individuals on the phone as he is leaving the Canton PD at 1:34 a.m. Exhibit K. Significantly, this specifically requested material and relevant evidence, which establishes that Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the Canton PD shortly after O'Keefe's death, was suppressed until after the first trial. It was suppressed. It was. Then we have some redactions, but I remember, and I'm sure all of you remember in the chat, Higgins testifying on the stand that he doesn't remember talking to anybody on the phone that evening, because that's why those butt dials came in that, even they were maybe 20 seconds long. Brian Albert had his phone in his bed with him while he was having a little sexy time with his wife. And that must be how he called Higgins. And then Higgins must have called him back with another butt dial, because after a couple more JMOs and ginger, he was sleeping on his couch. Doesn't remember any phone calls that night.
Yeah.
They also made a pretrial motion for his phone records, which was denied. And that's when the preservation order, he was tipped off about the preservation order. That's when he went to the military base, cracked his SIM card in half, threw his phone into 2 different dumpsters, and got a whole new number. So that motion to obtain his phone records was denied. Had they had that video, it would have shown him talking on the phone, and perhaps that motion would have been granted. I don't know, just speculation on my part.
I've speculated that the phone logs were due to cosmic radiation that caused the bits in the memory to flip and magically caused these logs to appear in the memory, even though the calls never happened. It was cosmic radiation that flipped the memory. That was it.
I like it.
Yeah.
And, celebrate. I think that's why they call it Celebrate. Like, it's a celebration of, celebration of cellular forensics. Celebrate is accurate in every other single case. Like, they're going to try Brian Walsh coming up. There's a conference today. He Googled such things as, how to dispose of a 120-pound woman's body and how to dismember, best ways to dismember, and other things such as like that. But his Google searches in the same exact county, in the same exact courthouse, according to Celebrate, are going to be 100% accurate, those timestamps. But, in Jennifer McCabe's case, not so much. Shield and a sword, my friends. Good luck with that. E. The Commonwealth failed to preserve exculpatory video surveillance from January 29th, 2022 in violation of a court order and Brady. So this is the exculpatory stuff that came out in October. Or actually, I think November 8th, 2024, while preparing for Ms. Reed's second trial and in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, Attorney Elizabeth Little, no relation, emailed Special District Attorney Hank Brennan, again requesting, inter alia, among other things, all raw video footage from the Canton PD, which shall include but is not limited to all cameras capturing the interior of the Canton PD and or the exterior of the Canton PD, including all parking areas, entrances and exits, and garages between January 29th, 2022 at 12 a.m. and at January 29th, 2022 at 11:59 p.m. On November 25th, 2024, ADA Brennan indicated via email that he would request that Canton PD provide all requested footage. Ultimately, the defense requested access to the Canton PD DVR system and drives that hold recordings from the security camera system so that the defense expert, Matthew Erickson, could obtain video files and corresponding log files from January 29th, 2022, between 12 a.m. and 11:59 p.m. Upon reaching an agreement with the Commonwealth, Matthew Erickson visited the Canton PD on the morning of December 12th of 2024 to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days, which means that the Commonwealth failed to preserve the specifically requested material and exculpatory footage relevant to Ms. Reed's case via standard forensic protocols, as they were obligated to do pursuant to the February 2nd, 2022 preservation order and October 5th, 2022 order compelling the discovery of all videos and related metadata. Shocking. F. January 28th, 2025. The Commonwealth produces more exculpatory blurry video surveillance footage, establishing that an unidentified person approaches the right rear taillight of the SUV as soon as it enters the Sallyport garage. So this was the latest dump, the latest dropping, which was just on January 28th of 2025. But it's blurry now. Because, you know, it's been copied and pasted and clicked and dragged so many times.
Digital
It's
data
been
usually
uploaded
doesn't
into
decay.
CapCut.
Digital data doesn't usually decay from being copied.
What if you
Isn't-
upload it into something like CapCut?
Mhm. Well, then you didn't preserve the original digital data now, did you?
No, you
Okay.
sure didn't. On January 28th of 2025, the Commonwealth yet again turned over additional Canton PD surveillance footage from January 29th, 2022, this time from an exterior camera depicting Ms. Reed's SUV being brought into the Sallyport garage. See Notice of Discovery, LVI Exhibit 1, Exhibit M. Quote, main driveway side exterior Sallyport with a whole bunch of numbers, .exe. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Miss Reed.
Why is it .exe?
I don't know, but somebody said that was like important. I'm not a techie, so I can't.
Well, .exe usually relates to an executable file. It's a program you run. .exe is not a extension for a video file.
Oh, so what does that mean to you? Because you do have a degree in computer.
I actually do have a degree in computer science. Yes. It means it's an executable file. It's a program I run. That's not a video format.
Interesting. And the shenanigans continue. Yes, people are saying it's a program file. That's odd.
Yeah.
Abby Video Jesus says it is a video file that carries the player with it. I don't know.
That doesn't really make much sense either. Just use VLC like everyone else does to run your videos. It'll run every video codec known to man.
I wonder if it has anything to do with the system that they were using, that ExacuVision system. I don't know. Well, moving on. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Ms. Reed's SUV immediately after the vehicle is brought into the Sallyport garage and then exit shortly thereafter. If this video were not blurred out, the surveillance feed would have captured yet another angle of the right rear taillight as it entered the Sallyport garage. At a certain point, it defies logic that all Canton PD video surveillance footage coincidentally cuts out, blurs out, or becomes grainy at the precise time the right rear taillight of the Lexus SUV should be in frame upon its arrival at the Sallyport. Yeah, it does defy logic. It strains credulity. This angle of video surveillance is exculpatory and was withheld from the defense prior to the first trial. B. Facts relating to the Commonwealth's intentional withholding of exculpatory statements made by seminal witness Jennifer McCabe. McCabe is a key Commonwealth witness. Her credibility is critical to the Commonwealth's case. On February 2nd, 2022, mere days after O'Keefe's death, the MSP obtained and forensically imaged McCabe's cell phone. Right, but she was allowed to delete messages to her kids. Before she handed it over, she testified to that. The forensic examination of McCabe's cell phone revealed significant exculpatory evidence supporting Ms. Reed's third-party culpability defense. Inter alia, establishing that McCabe Googled Haas long to die in cold at 2:27 a.m. on January 29, 2022, 3 hours before she supposedly discovered Mr. O'Keefe's hypothermic body in the snow on her brother-in-law, Brian Albert's front lawn. McCabe then took steps to delete that one search out of more than 4,560 on her phone, along with nearly every communication made on her phone in the hours following O'Keefe's death, only some of which were recoverable from her phone using forensic extraction software.
It seems like evidence tampering.
Yeah. It's not a federal crime.
It's a state crime too, in case we care.
Yeah, both. It could be both, right? But the close and long-standing relationship between the Albert and McCabe families and the law enforcement officers assigned to investigate this case is central to Ms. Reed's third-party culpability defense. Ken PD Sergeant Lank, a longtime friend of the Alberts, was the first officer to enter the Albert residence on the morning of January 29th, 2022, also known as the Friendly. Remember, they called him the Friendly. They were waiting on a friendly. Only when the friendly got there could they call the friendly in. That's when they let somebody into the house because he was the friendly. In preparation for trial, the defense uncovered location information on McCabe's cell phone, which proved that she went to first responding officer Sergeant Lank's home on January 30th of 2022, the day after O'Keefe's death. Well, there it is. We've been talking about this a lot, and I wasn't sure exactly what day it was that she went there, but there it is. The day after. The day after. Somebody is typing me. .exe is huge. That's a program which automatically executes as it is opened.
Right.
If they can ID the program used, it's over. I don't know. The rest of this is redacted, but I will refresh your recollection, chatters. You probably know even better than I do. And Kurt, if you don't know, Jennifer McCabe's story was that she went to Sergeant Lank's house with Carrie Roberts because all of a sudden they're besties the day after this happens. Carrie Roberts and Jen McCabe are, for some reason, driving around in her car together. And Carrie's daughter just happened to be friends, or Carrie's child happened to be friends with the Lank child. So Carrie was dropping her daughter off at the, first responding officer's house. And Jen says she sat in the car. Meanwhile, it's how cold? In the middle of a nor'easter, freezing, sat in the car. And, Carrie's a talker. So Lank's wife came out and talked to them, about the tragedy that had unfolded the day before. Because, she didn't say, come on in. Let me make you a cup of tea. It's cold out here. Why are we sitting in the ducking car? No. And then at some point she was asked, did you ever go in the house? And then she said, oh, maybe I went in there to go to the bathroom. But because the defense was required under the rules of Supreme Justice Beverly Cannone to turn over their impeachment evidence, Jennifer McCabe was able to be prepped about this fact that they knew that she had been there. And while that fact was not brought out on direct examination, during cross, she worked it into her testimony without being asked, and had a whole story for it. Moving on to the document again. After redactions on page 13. On May 7th, 2024, in accordance with this court's order that parties disclose all information to be used for impeachment purposes, Attorney Little emailed ADA Lally and ADA McLaughlin to provide location information from McCabe's cell phone establishing that she went to Sergeant Lank's house on January 30th of 2022. Unbeknownst to the defense, ADA Lally and ADA McLaughlin shared this impeachment information with Lieutenant Tully. Oh, that's a problem, don't you think?
Yeah. Why did you do that? What was your legitimate reason for sharing that information?
So he could pass it along to her.
See, that's not a legitimate reason, Melanie.
Right. No, I mean, in their mind, I think they think that
Okay.
they didn't do anything wrong. But let's see if we've got proof of this. Hold on. Because Tully's text messages became discoverable because of such things that he was doing in the Aidan Carney case, where he was text messaging with the special prosecutor and some witnesses, and they were all had some text messages about, setting up Aidan Carney, and eventually he went to jail because of that. One of those people is called Mafia Masshole on Twitter. You might recognize the name. On May 10th, it is a layperson, not a law enforcement person, like a layperson, and has also become, I think, besties with Jen McCabe. See, so there's that. On May 10th of 2024, in a then undocumented meeting, Lieutenant Tully, ADA Lally, and ADA McLaughlin met with McCabe shortly before she was scheduled to testify in the first trial. McCabe's materially inconsistent statement about meeting Sergeant Lank was not memorialized in any report or otherwise disclosed to the defense in advance of McCabe's testimony at trial in violation of Brady, Giglio, and Rule 14. Of course it wasn't. McCabe testified beginning on May 17th, 2024. During cross-examination on May 21, 2024, she testified that she received a text from her sister, Nicole Albert, on January 29th, 2022, stating, quote, "We'll get more info tomorrow. Don't want to text about it," end quote. To which she responded, "Right." I mean, anybody who's ever watched The Godfather knows that you don't talk on the phone and you don't put anything in writing. You're going to meet behind, Satriali's meat market in the basement. What? Exhibit O. So here's Exhibit O. That's part of the transcript. When Ms. McCabe was asked whether anything significant happened the next day on January 30th, 2022, McCabe volunteered the following story. "I went to the O'Keefe's house. On the way home, Kerry Roberts' daughter is good friends with Michael Lank. So we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Kerry are friends, and she, jumped in the car and was consoling Kerry and asked how the O'Keefes were doing. And, we talked to her." And that is what it says. It says that it is transcribed as Kerry Roberts' daughter is good friends with Michael Lank. I don't know if it was transcribed improperly, but I think that Kerry Roberts' daughter is good friends with Michael Lank. I mean, he's a grown man. I think her daughter is school age. So, I mean, look, I could be wrong. I don't know. She testified that she was at the house for approximately an hour and that she, quote, might have ran in to go to the bathroom, end quote. Then there's a redacted half a sentence. And then it says, on cross at trial was the first time McCabe mentioned going to Sergeant Lank's home on January 30th, 2022. When pressed further, she admitted that she had discussed this issue at a meeting a couple of weeks prior at the DA's office. Oh, well, guess what they forgot to tell the other side. She testified that at the meeting at the DA's office, quote, "I was asked, oh, were you at Michael Lank's on the 30th? They prepped her. They clearly prepped her for that. That is so out of bounds. Am I wrong?
I mean, well, you have to get into the difference between prepping and coaching to be fair. But it's not great if they're giving her information that
Was turned over to them as a result
to change her testimony. That's a problem. Like what a lawyer can do in principle is they can take the testimony you have and they can help you change it and how you present it, but they can't like just magically change your testimony. That's not really cool.
Well, this was her pretrial prep, and this was based on information they received from the defense that was impeachment evidence. And we'll go on to see if they allege any violations of the rules of professional conduct. She admitted that, quote, "At first I said, no, I've never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there. And that was the extent of the conversation," end quote. She further testified that one, Tully did not ask her any follow-up questions about why she went to the personal home of Sergeant Lank the day after O'Keefe's death. You think so? That's really good police work. And 2, that he did not take any notes.
Yeah, of course they didn't take notes. That way they didn't have to turn over the notes because they don't exist.
Right. And he didn't ask her why she was there, so she was free to make up a whole story, I guess. On May 29th, 2024, only after the defense was deprived of the opportunity to effectively cross-examine McCabe and Carrie Roberts about their visit to Sergeant Lank's house, Lieutenant Tully memorialized his meeting with McCabe. Really? That's when he decided to make a report after she's off the stand on May 29th? This meeting was what? May 10th? Hold on. May 10th. He doesn't write his report until May 24th, and she was on the stand May 17th, starting May 17th. I think she was on for more than one day. It might have been 3 days.
Why are we writing reports in the middle of the trial?
Because you don't want to have to turn them over.
Ah.
Especially not before she testifies. Gets to explain it.
Aren't reports usually written in a somewhat contemporaneous fashion to when the underlying thing happened?
Oh, I'm so glad you asked because, yeah, they're supposed to be. However, we know from all the pretrial shenanigans that we looked at, over a year ago, that all of the original Canton PD reports, or Michael Proctor's witness statements particularly, were not recorded in any way. There was no body cam footage of them. They were not even, he didn't even turn on the voice note on his cell phone. And they were often transcribed something like 2 to 3 months later. There would be like, I visited Jennifer McCabe at her home on January 30th. And for example, I'm like, don't you guys correct me on the exact dates because this is hypothetical. And then the report of this witness statement would be dated April 10th, So yeah, that's how they do it. Details are not important. Nothing was signed by the witness. It was just, and then that way they got to throw Proctor under the bus at trial and be like, I never told him that. I can't help what he wrote down. And they were told, there's no notes. They asked for notes and nobody took notes. No, of course not. Notably, Lieutenant Tully memorialized McCabe's inconsistent claim that she went to Sergeant Lank's home to pick up Carrie Roberts' daughter. Oh, well, that's interesting. Tully's report says they went to pick up Carrie Roberts' daughter, but on the stand, she said they went to drop off Carrie Roberts' daughter. The truth doesn't change. And I guess Tully's a moron too, because he wrote it down wrong. I can't wait for her to throw him under the bus at the next trial. It's not what I told him. He didn't take any notes, so he just must have wrote it down wrong. Lieutenant Tully's May 29th report of 2024, which also omitted any reference to McCabe's exculpatory statement in which she denied she ever went to Lank's house, was not disclosed to the defense until June 4th of 2024, Exhibit P.
Yeah.
And then we come to paragraph C, which is completely redacted, all the way to the bottom of page 15, going into page 16, which is also completely redacted. So we don't even know the header of what point C is, but I can only imagine that it is, it's juicy, fiery, strains credulity.
The whole thing is redacted. Wow, that's a lot of redactions.
15. Oh,
wow.
Wait, more. And then half of page 17. So whatever's underneath there.
C's a mystery.
Look the other way. They don't want you to know. C for catastrophic to the Commonwealth's case. Ooh, how do you like that alliteration? Not bad. Catastrophic to the Commonwealth's case. Moving on to point Roman 2, argument. A, the Commonwealth has engaged in numerous Rule 14 discovery violations and constitutional violations under Brady v. Maryland and its progeny.
Yeah, we solved a lot of these issues like 60 years ago. So there's that.
In a lot of ways, Massachusetts is sort of like all the way back in like the Pilgrim days of law, like 60 years ago. I mean, I think they're still like in maybe the 1800s.
Fair.
It might not even be into this century yet. Ms. Reed's constitutional rights to effective assistive counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 6th and 14th Amendment to the United States Constitution require that the Commonwealth disclose certain evidence in advance of trial, citing every single constitutional provision known to man in a whole bunch of cases. Like Commonwealth v. Mitchell, defendants have an unquestioned right under the 6th Amendment and Article 12 to obtain relevant evidence that bears on the question of his guilt or innocence, or which otherwise helps his defense. Pursuant to Brady v. Maryland and its progeny, defense counsel is entitled as a matter of due process to all evidence that is favorable to the accused and material either to guilt or punishment, including impeachment evidence and evidence necessary to place the witness in his proper setting and put the weight of his testimony and his credibility to a test. Citing U.S. v. Bagley, Alford versus the U.S. from 1931. Is that where the Alford plea came from? Off topic for a sec. I don't know.
1931 doesn't sound right off the top of my head.
All right. Just thought you might know. Moving on. Brady disclosure also extends to disclosure of information useful to the defense to attack the reliability of the police investigation and the police methods employed in assembling the case. Citing Kiles v. Whitley, U.S. Supreme Court case 1995, and Lindsay v. King. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of trial and prepare her defense. Massachusetts rules of criminal procedure clearly state that the Commonwealth must provide certain mandatory and automatic discovery of evidence within the possession, custody.
Yeah. Alford was 1970. Yeah,
oh, okay.
So, yeah,
Cool. Is it spelled the same way?
Alford.
Yeah. Okay, cool.
Yeah, so. No.
Good to clear that up. In order to meet its mandatory discovery obligations, and that is citing Massachusetts Rule of Criminal Procedure 14A1A as amended. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, and tangible objects, all intended exhibits or reports of physical examinations of any person or of scientific tests or experiments, and statements of the persons the party intends to call as witnesses, which would include.
That'd be helpful.
The Commonwealth is also required to provide any facts of an exculpatory nature.
I love how we're explaining the basics to them. Like it's the first time they've heard of it.
They don't know.
They
don't know.
It's like normally I say it's a little patronizing, but I'm not sure that's true in this situation, but okay.
They didn't seem to know it at the time. So
yeah,
we can't assume that they know it now, because, you know, if you assume, just make an ass out of you and me. And that is citing footnote 5, which is the reporter's notes to Rule 14. This provision requires that the prosecution to provide automatic discovery of any facts of an exculpatory nature. Derives from the constitutional requirement established in Brady v. Maryland from 1963. That is the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. This duty is also an ethical one imposed on the prosecution by...
It sure is. It sure is.
There it is.
They have a whole section in the rules of ethics just for prosecutors. They have a little chapter just for them.
And there's the rule if anybody wants to look it up. SJC Rule 3:07, RPC 3.8D. Prosecutors are held to a higher standard in some respects. The rules also state that the defendant may move for discovery of other material and relevant evidence not required by subdivision A1. Here, on February 2nd of 2022, the Commonwealth was ordered to preserve all physical evidence, including video surveillance footage in Stoughton District Court. Exhibit A. Subsequently, on October 5th, 2022, this court ordered the Commonwealth to produce all videos in connection with the case and associated metadata. Exhibit B. Notably, this prosecutorial duty to produce evidence covered by Rule 14 extends beyond just the prosecutor to all agents of the Commonwealth, including police.
100%. Yep. The Supreme Court said that a long time ago, too.
And did you know that certain, I'm breaking from the document for a second if you're listening and not watching, that in Norfolk County, there are certain troopers that are assigned to the Norfolk County DA's office. Michael Proctor, Yuri Buchanan, they're all assigned. You know, that's not the way we do things here in New York. That's not the way we do things. So that is odd to me. That certain, you know, officers, law enforcement officers are assigned to the DA's office.
Doesn't the DA's office in New York have like police that do investigations for the prosecution that are separate and apart from the normal police?
No.
No?
I mean, like we have, like Long Island is Nassau County and Suffolk County. You have the Nassau County Police and the Suffolk County Police. I don't know, Scott, if you're here, you could chime in on this because Scott was NYPD. I don't know if they do it differently.
I was under the vague impression, at least in Manhattan, that the district.
Oh, he says, yeah, in New York
police.
City, Scott says, I'm talking about Nassau, Suffolk. They are assigned NYPD detectives. Dun, 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 in New York City. Thank you. Thanks, Scott, for clearing it up. The prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in the case. Commonwealth v. Sleeper.
Great name.
Yeah, it's a great name for a case.
It's a sleeper case.
Prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participated in the investigation and presentation of the case.
Yeah. All those things.
All those things. I mean, shouldn't have to keep rehashing this, but apparently we do. As set forth herein, the Commonwealth has repeatedly violated its discovery obligations under Brady v. Maryland and its progeny and Rule 14. Here's why. Number one, the Commonwealth's production of the April 23rd, 2024 inverted video from the Canton PD Sallyport Garage violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence. First, the Commonwealth violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence by withholding the adverted video from the Canton Sallyport until after the start of trial and after the Commonwealth had already filed its certificate of compliance on April 23rd of 2024. See Rule 14. At best, the inverted video had been in the Commonwealth's constructive possession since January 29th, 2022. At worst, this video evidence was intentionally, this is strong. This video evidence was intentionally manipulated and inverted by the Commonwealth and its agents sometime thereafter in an effort to defraud the jury into believing that no law enforcement officer approached the right rear tail light of the defendant's SUV upon its arrival in the Canton PD Sallyport. Either way, the Commonwealth's production of the inverted video in the middle of trial and after it had filed its certificate of compliance violated Rule 14.
Yeah, why are we doing discovery in the middle of trial is a good question.
And you remember all of the arguments on objections were held at sidebar. And I remember Alan Jackson jumping up when this video came out and they went to sidebar and all the sidebars have been sealed. We don't know what they talked about, but you can bet your ass that he was vehemently objecting to this even coming in, to the jury seeing it. And we can understand that it was overruled quickly by the judge. And so here's the time to talk about it. The time is now. 2, the Commonwealth violated Rule 14 and Brady by withholding exculpatory impeachment evidence establishing Higgins was speaking to some unidentified individual on the phone at the Canton PD at 1:34 a.m. on January 29th, 2022. After trial in this matter, on October 10th, 2024, the Commonwealth produced previously withheld video surveillance from the Canton PD's church side exterior and rear lot cameras, which show, inter alia, Higgins arrive in the parking lot of the Canton PD at 1:26 a.m., enter the Canton PD, and speak to some unidentified individuals on the phone as he is leaving the Canton PD at 1:34 a.m. Exhibit I. The Commonwealth namely ADA Lally and ADA McLaughlin, suppressed exculpatory impeachment evidence, redaction. That's an ethical issue. Yeah. Could it be a crime too, or could it just be ethical? There's a whole bunch of redactions after that. Any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory, according to some cases. This exculpatory video surveillance footage was in the Commonwealth's custody and control since January 29th of 2022, and at the time of trial was in ADA Lally and ADA McLaughlin's actual possession. By withholding this exculpatory evidence and failing to produce this information until after trial, ADA Lally and ADA McLaughlin violated Ms. Reed's constitutional rights as set forth in Brady v. Maryland and its progeny, Rule 14, this court's October 5th, 2022 order compelling the production of video evidence, and the ethical duties imposed on prosecutors by SJC Rule 3:07 and the Rule of Professional Conduct 3.8D. Can you say mic drop? Mic drop. And now you know, my friends, why it is that Hank Brennan was showboating a week ago and got up there and made that whole monologue. They practiced in the mirror for many, many days, accusing the defense of all things nefarious as he called them, and let that lie become the truth for a week while the media ran with it, because they knew this motion was coming. They knew the deadline for this motion was the 21st. And then the judge, in her infinite wisdom, decided to suspend that hearing in her very shaky and breathy way, let it sit out there for a week, and then withheld this motion from the public until today, which is 2 days after that hearing on Tuesday, and let the media and perhaps Mr. Brennan tamper with the jury for a whole week because they knew this was coming.
I tell you what I know is coming. There's a pretty high probability that Arca's not going to be allowed to testify at the next trial. That's what's being teed up
by the Commonwealth,
and also by the judge and their questions. The nature of the questions and the nature of the interactions was all about Arca. Like, a lot of people have said this is about Jackson, but at least in my humble opinion, the tenor of the conversation really wasn't about Jackson. It was about Arca. Yeah,
but they would have no legal basis to exclude them. There's no prejudice. Where's the prejudice?
I don't know. Reasons.
I think she's been looking for a reason to get rid of Alan Jackson since like the day he came onto this case, because, you know, it's a privilege to practice in Massachusetts, Mr. Jackson. It's a privilege. She loves to spew that. It's not the way that we do things in Massachusetts. And I don't think there's any prejudice to the Commonwealth. They had a full voir dire. I can't see a legal basis for excluding them. And so I don't know what she's thinking, but I think Brennan is afraid of Jackson. He wants him out. And also, they're afraid of Arca because it proves that John O'Keefe was not hit by a car.
Yeah, you're operating under the presumption that there needs to be a legal basis for the judge to make a decision. Lol.
Yeah. Well, wait. If she, let's say she decides, okay, Mr. Jackson, I'm going to fine you $1,000 for, you know, your alleged misrepresentation, which I was going to go over at length today because I really don't think it was a misrepresentation or a lie. But we have this. If she did, you know, say, okay, you know, you're fine, but she excludes Arca, right? Can they take an interlocutory appeal on that?
I don't think they can. I don't think they can take an interlocutory. It doesn't seem to fall into any of the traditional categories.
But it's evidentiary, right? I mean, you know.
Yeah,
I don't know.
Judges make evidentiary decisions all the time. They're not normally appealable.
But if she took him off the case, that would definitely be automatically appealable. And that would, in her right to counsel.
Well, I mean, she does have attorneys, obviously, just it would not be Mr. Jackson. So she has a right to an attorney, not necessarily Mr. Jackson.
But like in Delphi, right, when they removed both of the attorneys,
well, that was completely messed up procedurally.
Photos leaked. Yeah,
that was procedurally wackadoo. Which this might be too, to be honest.
Yeah.
And yeah, and even in the Delphi case, when that was brought on that, it was brought as a writ of mandamus.
Right.
I didn't think they were going to do it for the same reasons, because it was so extraordinary. So
Right.
I was surprised when the Supreme Court of the state decided to intervene, because it's like, that's a really ordinary thing to do.
Yeah.
And it's like, okay, so.
But you're
Do
you're
you
entitled
really
to the counsel of your choice.
But do you really
yeah?
think the Supreme Court of do you really think the Supreme Court of Massachusetts is going to go out of its way to grant a review like the Supreme Court did in Illinois with Delphi?
I do, because
I'm not feeling it.
they when they appealed the denial of the cell phone records of Jennifer McCabe and I think it was Brian Albert, they heard that right away. I mean, they did.
All right, fair enough.
It wasn't during trial.
Fair
It was
enough.
pre-trial, but they did. And I mean, come on, with the eyes on this case, this is a worldwide story. This is a worldwide audience. I don't know.
Fair enough.
I don't know. It's nefarious to say the
Indiana,
least.
not Illinois. Sorry, my bad.
Oh, it was Indiana, yeah.
I
Did you say Illinois?
I
didn't.
I did.
I didn't catch
I
it.
did. I made a mistake.
That's okay. Sorry. I'll allow it. Okay. Point number 3. The Commonwealth violated Rule 14 in Brady by withholding exculpatory video surveillance footage establishing that an unidentified person had unfettered access to Miss Reed's right rear tail light of the SUV immediately after its arrival in the Canton Sallyport garage. Just last month, on January 28th, 2025, the Commonwealth provided additional Canton PD surveillance footage from January 29th, 2022, 3 years later, almost to the day, this time from an exterior camera depicting Ms. Reed's SUV as it was driven into the Canton PD Sallyport garage. And we know that it was backing into, because he said that, Alan Jackson said that in open court. He's not saying that here. He says, as it was driven into Exhibit M. This camera angle should have had a clear and unobstructed view of Ms. Reed's taillight as it was driven into the Canton Sallyport garage. However, yet again, the footage is too blurry and grainy to make out the condition of the taillight. Notwithstanding that fact, the footage is exculpatory and shows an individual approach the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport and then exit shortly thereafter. My question, were they holding a sledgehammer? This video surveillance footage has been in the Commonwealth's possession since January 29th, 2022, and was withheld from the defense for 3 years and only produced after the trial in this matter. I mean, this is... You think this is grounds for dismissal? I mean, what are we doing here? The shenanigans, the tomfoolery, and the ballyhoo are off the charts.
I mean, in at least in the federal system that I'm aware of, the typical remedy for a Brady violation after the fact is just a new trial with the evidence.
Mm-hmm.
So because those are when the defense has made those kinds of objections, be like, oh, we're just now learning about this material and it was Brady and not disclosed. The typical remedy is, well, you get a new trial and now you have the evidence. So everyone's happy.
But that's typically after a conviction when the defendant is sitting in jail.
This is very true.
Right. Or prison.
And this is an ongoing live case, which is more akin to Baldwin.
Mm-hmm.
In that situation, it's like, oh, well, this is a live proceeding. So that presents different problems.
Yeah.
Although, to be fair, while I think the judge's decision in Baldwin was permissible, it still was a fairly extreme remedy. I mean, even the judge knows it's an extreme remedy. So I don't necessarily think it was required even in Baldwin, but that's another such situation for another discussion, maybe.
But it certainly did make for a wild day in court when Carrie Marcy put herself on the stand. I mean, that was like
that was outstanding.
TV.
That was outstanding. You got to love it when the DA is like, "No, I really want to take the stand. I really want to testify." I'm like, "Really?"
I was screaming. I'm like,
really?
"Don't do it! Don't do it!"
Really? Who told you this was a good idea?
Oh my gosh! This video surveillance footage.
Wild.
Well, but the argument here is, look, if we had this evidence before the first trial, she likely would have been acquitted. Now there's a mistrial. Now you're turning it over to us. I mean, I don't see any other appropriate remedy here. My opinion. I don't know. Let's keep going. Maybe they've got the answer. This video surveillance footage directly contradicts Sergeant Buchanan's false testimony at trial, in which he claimed that video surveillance footage established that no one from law enforcement approached the right rear taillight of Miss Reed's vehicle. And now they've got newly discovered video that's just turned over where, in fact, somebody actually, in fact, did. I want to even go back and read that again to make sure.
Mm-hmm.
The footage is exculpatory and shows an individual approach the right rear tail light of Ms. Reed's SUV immediately after the vehicle is brought into the Sally Port and then exit shortly thereafter. I mean, hello? Ms. Reed's defense at trial in this matter was that law enforcement removed taillight material from the Lexus SUV and planted the evidence at 34 Fairview Road. Notably, no taillight material was found at the crime scene until after the Massachusetts State Police took custody of Miss Reed's vehicle and after it arrived at the Canton PD Sally Port. Any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory. As such, ADA Lally and ADA McLaughlin violated Ms. Reed's constitutional rights as set forth in Brady v. Maryland and its progeny, Rule 14, and the court order of October 5th, 2022, and the ethical duties imposed on prosecutors by SJC Rule 307, RPC 3.8D, by withholding this video surveillance footage from the defense at trial. They're throwing stones now. 4, the Commonwealth failed to preserve exculpatory evidence in violation of court order. The Canton PD and the Norfolk County District Attorney's Office failed to preserve material and exculpatory video surveillance footage and associated logs in violation of the Stoughton District Court's February 2nd, 2022 preservation order and this court's October 5th, 2022 order compelling the discovery of all videos in the Commonwealth's possession and related metadata. Moreover, the metadata and log files underpinning this Canton PD surveillance footage from January 29, 2022 are clearly exculpatory, and thus the Commonwealth had a constitutional and statutory obligation to preserve the original surveillance footage from the Canton PD in its entirety. To be clear, the condition of the right rear taillight of the SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in this case.
I thought one of the most highly contested issues was the laws of physics.
Yes, well, that too, because, you know, the laws of physics show that if it hit John O'Keefe's arm like this, it wouldn't have broken the taillight. The laws of physics do show that if someone took a sledgehammer to a cracked taillight, might indeed shatter a taillight. So I think we're both right. The footage
I'm nominating Trooper Paul for a Nobel Prize in physics. His exciting revelatory expansion of physics is truly worthy of an award.
Chef's kiss. Kinematics. Definition of kinematics.
But what is physics anyway? Says Trooper Paul. That is the question that haunts us all.
Right. It just did.
It just did.
It just did.
Just did. Wow, I'm convinced.
The footage that has been produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability of the Canton PD's video surveillance footage obtained from the Sally Port on January 29, 2022. The Commonwealth has produced numerous video files without any way to verify their authenticity. You know, in New York, where I practice, authenticity is a thing.
Authenticity is a thing in the rules of evidence. I remember, like, we need to know this. We need to know this thing is what it purports to be.
Yeah, remember the best evidence rule? Like,
I do remember the best evidence rule. Yeah,
screenshot of a text message is not the best evidence.
The text message itself will be better.
Of course. And in such cases, you could object on best evidence grounds. And of course, that evidence would never see the light of day in front of a jury, right? But
sure.
Pshaw.
Yeah.
This case, when you're an attorney and you are reading about and following this case, it makes you question your sanity. It makes you question everything that you've ever known or learned about the law, you've ever practiced, you were ever taught in law school, you've ever learned in your decades of experience. It makes you question everything. It is gaslighting to the nth degree. I've never seen anything like this.
Yeah.
I often have to call my lawyer friends and say, am I crazy, or is this a thing? And like authentication foundation, isn't that a thing anymore? Did I miss like a change in the law somewhere? Especially with the advent of AI, where anything could be faked. A deep fake of Tom Cruise, video, like you could deep fake anything now. Somebody needs to tighten up their game over there in Norfolk County. These video files include a file capturing the interior of the Sallyport garage with a 42-minute gap missing at the precise time that the feed would have showed an unobstructed view.
That's 7 Nixons worth.
Yeah. Right. A 42-minute gap.
Yeah.
And it's like, yeah, no big whoop. No big whoop. So what? We know that's the exact crux of your case and the exact time when it would have exculpated you from being the one who did anything nefarious that evening. But, look the other way while we pin it on the girl. Would have showed an unobstructed view of the right rear taillight of Miss Reed's 6,000-pound SUV as it entered the Canton PD Sallyport garage, in spite of the fact that the Commonwealth claims the video surveillance feed is motion activated. The mid-trial production of an inverted video produced by the Canton PD in an attempt to save face for the gap in footage, which improperly depicts right as left and left as right, and falsely suggests that no one from law enforcement approached the right rear taillight, and a blurred out video that obstructs what would otherwise be another clear view of the right rear taillight of the SUV as it entered the Sallyport garage on January 29th, 2022. It is not a coincidence that none of the many cameras in the Canton PD Sallyport garage captured the condition of the right rear taillight upon its arrival at Canton PD and before the first pieces of taillight lens material were recovered by law enforcement at 34 Fairview Road. The fact that the Commonwealth and its agent, the Canton PD, failed to preserve the footage in a forensically sound way and allowed critical evidence to be destroyed is not a coincidence and goes to the heart of Ms. Reed's defense and the credibility of some of the Commonwealth's most central witnesses.
To some degree, I don't even really care if it's a coincidence because they had the affirmative duty to do so and failed to do so. So that's kind of sufficient.
Mm-hmm. But let's throw it in there anyway. I would.
I mean, fair.
I mean, at this point, my snark is exhausted at this point.
That's okay. I've got reserve snark.
Excellent.
I've got plenty of reserve snark. No problem.
Pull out the reserve tank. We're gonna need it. We're gonna need like a tank of nitrous also if we're gonna even get through this. That's a Grateful Dead reference. You guys know. You could buy balloons in the parking lot. Nitrous balloons, $5. Giant balloons too, like the hippity hop balloons. I don't know how they still get away with that, but anyway. Even if ADA Lally was not actually aware of the footage, a reasonable prosecutor exercising due diligence would have been aware. ADA Lally had an ethical, statutory, and constitutional obligation to obtain this footage. See all of these citations.
Yeah, which again is like a little insulting that I need to find a case for this. It's kind of like, really? Do I really need to find a case that says, yes, you, prosecutor, have an obligation to give me the exculpatory information, including evidence that could be used to impeach it? I mean, there's Brady and Giglio, but do I really need to cite some additional cases for these relatively simple propositions?
Well, Massachusetts, you better put some Massachusetts cases in there. Because when I was looking at the voir dire of Dr. Wolf yesterday, or it was Dr. Rentschler, she did say he had testified in many courts in all different states. And she was like, well, have you ever testified in Massachusetts? And she made him look at his CV as a list of T&D and tell her which ones were in Massachusetts. Like, guy's a biomechanical engineer with skills and credentials out the wazoo. And he's coming up to contradict Trooper Paul. And you're worried about exactly which cases were in Massachusetts, Dr. Rentschler.
Maybe the biomechanics are different in Massachusetts.
Right.
I mean, I know that gravity can change a little bit based on location, so maybe other laws of physics are like that too. Maybe they're slightly different in Massachusetts.
Yeah, what if you were in like Denver? It's a mile high,
Mm,
altitude and things.
mm.
Maybe if you were in Utah in the mountains, maybe the altitude would affect the physics.
Yeah. And
Hmm.
also, I've figured it out for the Commonwealth, the taillight thing with the video when it appeared to be white. What
Mhm.
really happened was a miniature black hole appeared just in between the lens of the camera and the taillight, and it caused a Doppler shift to
Yeah.
cause the light to appear to be white, even though it was really red.
Mhm. Yeah, luminescence.
Mm.
Following the February 2nd, 2022 preservation order, ADA Lally should have, and a diligent prosecutor would have, promptly notified Canton PD to preserve any existing footage and inquired about whether the DVR system overwrites or deletes old data. Yeah, what that would you would think. The certificate of compliance of ADA Lally signed and filed with this court specifically includes a representation that the prosecution made a reasonable inquiry to disclose and make available all discoverable evidence. ADA Lally did anything but, and the Commonwealth is responsible for the resulting loss of this critical exculpatory evidence, which cannot be cured short of a dismissal of this case. Yeah, that's what they're asking for. That's what they want. The case dismissed. 5, the Commonwealth withheld exculpatory statements by McCabe in flagrant violation of its obligations under Brady and Rule 14. The Commonwealth withheld the May 10th, 2024 exculpatory statement of McCabe in which she denied traveling to the personal residence of first responding officer Sergeant Lank on January 30th, 2022, the day after O'Keefe's death, and then claimed she went there with Kerry Roberts to pick up Roberts' daughter. Clearly, the Commonwealth was required, pursuant to their Rule 14 discovery obligations, to disclose the false statement made by McCabe to Lieutenant Tully regarding her visit to Sergeant Lank's house. Rule 14 requires automatic production of all statements of the persons the Commonwealth intends to call as witnesses and any facts of an exculpatory nature. The Commonwealth's decision to preemptively reveal impeachment evidence uncovered by the defense to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a clear-cut violation of the Commonwealth's constitutional obligations under Brady and its progeny. B. Oops. Hold, please. The
Also, John O'Keefe's body moved due to quantum tunneling. Now, normally quantum tunneling only happens on the quantum level, as the name normally implies.
Huh.
But all the many, I don't even know how many quantums are in a human body, but all of them all quantum tunneled. That was it. Yeah.
That's like way above my head, but I'm sure there's
Yeah.
some people that get that reference in the chat.
No problem. I'm here to help. I've got ideas, baby. I've got ideas.
I know. You and I might not agree on everything, but we do agree that John O'Keefe was not hit by a car and a car did not hit John O'Keefe.
Yeah.
So we've got that going for us. When the Commonwealth fails to comply with its discovery obligations, the court has the ability to impose remedial sanctions. See Rule 14. For failure to comply with any discovery order issued or imposed pursuant to this rule, the court may make a further order for discovery, grant a continuance, or enter such other order as it deems just under the circumstances. Clarifying permissible orders include dismissal of charges with or without prejudice. And this is Rule 14, effective March 1st, 2025, which is only, I don't know, are we in a leap year? I don't know what, today's the 27th of February.
No.
So March 1st is on Saturday.
2 days from now.
2 days from now. Such remedies, and this is interesting because Rule 14 was just redrafted, and guess who was in charge of the redrafting? Justice Beverly Cannoni was the head of the committee that redrafted these rules.
That's exciting.
And it is interesting if you want to ever, I'll send you them. I haven't had a chance to do this yet. Compare the old Rule 14 with the new Rule 14 to see if perhaps this case was in her head when she decided to make all these changes to obligations of prosecutors, for example, let's just say.
That is a power move that I don't know that many people have contemplated. Let me actually just change the underlying rules to get the prosecutor out of this problem. That is chef's kiss, next level thinking, man. Wow.
And I haven't I haven't had a chance to dissect the rules to see if they're more helpful to the prosecution or the defense this go around. If they were changed to prevent some of the shenanigans that went on during the Karen Reed trial, but I can send you all the info if you'd like to do it, because you like that kind of stuff. And I don't know, just an idea if you ever want to do a show on it. That there's a lot of people who want to know. I've had a lot of emails asking me to do that.
Sure,
So,
why not? Send it over my way. We'll do a show. It'll be fun.
All right, cool. Let's see. Where are we? Such remedies can include the exclusion of evidence and even dismissal of the criminal charge. Now, that is a case from 1985. And it's a Massachusetts case. And another Massachusetts case from 81. Another one from 2024. There is no question that on failure of the Commonwealth to comply with a lawful discovery order, a judge may impose appropriate sanctions, which may include dismissal of the criminal charges. Dismissal is appropriate as a remedial sanction as a way to cure any prejudice caused by the violation of a discovery obligation and ensure a fair trial. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable harm to a defendant that prevents the possibility of a fair trial. And I mean, really, that argument can be made here because there was a mistrial and she's having to undergo a second trial. I mean, I see where we're going with the appellate issue on this, but again, most of those people are already in prison. The Supreme Judicial Court has identified two parallel legal principles governing when dismissal might be necessary, balancing the rights of defendants against the necessity for preserving society's interest in the administration of justice. It's a 2017 case out of Massachusetts, which, they don't really seem to care about the defendant's right to a fair trial in Massachusetts because Hank Brennan gets up there and keeps talking about the Commonwealth's right to a fair trial. He has gotten up in open court and said that at least 5 times. Is that a constitutional right? Does the Commonwealth have a right to a fair trial? You tell me.
Well, I wouldn't say as a matter of the Constitution they don't, but I would say that they have the right to have the rules as they exist to be fairly applied. Now, those rules in some cases may favor the defense. For example, beyond reasonable doubt that favors the defense. But I think that they have the right to have, or they have the right to have the rule fairly applied, even both ways. I think fundamental fairness is still a fundamental guarantee. And one of the things that sort of bothered me so much about the hearing that you guys just covered recently, the one on Tuesday, was not so much that the judge was being so harsh on the defense, but that she just isn't being even in that application, right? Certain judges like certain things a particular way. They care about certain things a particular way. And as long as you understand the rules of the game and it's fair to both sides, then, it's not such a big deal. So the problem is the uneven, and I'd say grossly uneven application where any fault of the defense is seen as, the worst crime of all time. And every fault of the prosecution is seen as a minor error and omission that we can sort of hand wave away. It's like pick one of those and apply it both ways. That's what I would say.
And we've seen that with regard to just the selective persecution of defendants in Massachusetts too. Like these witness intimidation laws, they have this overly broad witness intimidation law that if you hurt someone's feelings, you can be charged with a felony. And we've seen it selectively prosecuted based on whether or not people think that John O'Keefe was hit by a car. It's wild. Now I just lost the screen where that is because I pulled up another screen. Hang on a second. Where did it go? Let's walk amongst yourselves for a second.
I can see the screen. But
you can see it, but I can't find it on my one of two screens to actually, unless it's not here, to actually like scroll through it. Hold on. It disappeared.
While we're waiting,
I'll
entertain you a song. I don't want to wait for love to be over.
Oh, I love that. That's Paula Cole. How do you know the soundtrack of my life?
Because I understand you.
Oh, somebody understands me finally. All right. Well, I see, because somebody just sent me the affidavit of Alan Jackson, which is attached to this. And so that came up. Wait, did they consolidate themselves? Hold on. No, unless that went ahead of the other one, because now that one's 111 pages. It's all right. I'll find it. Just got to scooch some things around. Let's do this. Well, do we remember what page we were on? Hold on, wait, let me go back here for a second.
There doesn't seem to be a page number. Top line is Administration of Justice, Bridgman versus District Attorney. I don't know if that helps.
That's all right. We'll find it. I got it. I pulled it up again in a different screen. Do. Hold on.
I'm just a regular Joe with a regular job. I'm your average white suburbanite slob.
What is this? Open with preview. Open with preview. Go.
I got an average house with a nice hardwood floor. My wife, my kids, job, my kids and car. My field of table and a Cuban cigar.
Administration of Justice. Where's that page? There it is. I got it. Hold on. It's going to be a seamless transition.
Seamless.
There we go. Never fear.
There you go.
Administration of Justice.
Wow, there you go.
Well done, eh?
Excellent.
First, where the prosecutor fails to disclose evidence the defendant is entitled to receive it, and the defendant is prejudiced by the failure to disclose, a motion to dismiss should be allowed when the defendant can make a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Alternatively, a prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice. In such circumstances, dismissal would be appropriate if needed to create a climate adverse to repetition of that misconduct that would not otherwise exist. 1. Dismissal is the only appropriate remedy for the Commonwealth's egregious and repeated non-compliance with its discovery obligations. Given the extreme governmental misconduct in this case and the irreparable nature of the harm to Ms. Reed as a result, dismissal is appropriate and necessary under both legal principles outlined by the SJC. A. The Commonwealth has failed to disclose evidence that it was obligated to disclose to Ms. Reed, which severely prejudiced her such that a fair trial is not possible. Here, Ms. Reed has been irreparably prejudiced by the Commonwealth's discovery violations in this case. The first trial resulted in a hung jury precisely because this was a close case.
Was it though? Was it?
It shouldn't.
I didn't think it
Wasn't.
I didn't think it was close. I thought that as a judge, I would have more seriously considered entering a directed verdict after the end of the state's case because the case was an absolute shambles.
Not only should the case never have been brought, but it should have been permitted to get to the jury, right? That's what you're saying. And also, we're still here. We're still here. But according to the juror, because there was a juror interview that was done, and according to the jurors that came out afterwards, and all of those affidavits were submitted, or the affidavits of affidavits were submitted on the appeal, they were hung on count 2. So apparently some people thought that he was hit by a car.
Well, apparently there were 8 people ready to convict, and I don't begin to understand how.
I don't think, did they understand that maybe count 2 lesser included might have just meant drunk driving and not that he was actually hit by a car? Because that's the only thing that I can reconcile it. Or did some people think it wasn't intentional? She may have done it by accident. And so she wasn't guilty of leaving the scene of an accident causing personal injury or death. Because I couldn't reconcile that. How could they acquit on count 3, which was leaving the scene involving personal injury or death? How could they acquit on that? Because if she did hit him, she did leave the scene, right? So
yeah, one would imagine.
Unless they're saying she didn't know she hit him, some people, or some people were just like flat out not guilty. Yeah, that's what I'm saying, Olivia. Right, exactly. It sounded like they thought some of the lesser included just meant drunk driving. That's what I thought, but it clearly didn't, because there was no just plain old drunk driving charge.
Well, for whatever it's worth, incidentally, at least as a matter of federal law, the federal courts have said clearly, including the U.S. Supreme Court, that they don't care about mutually inconsistent verdicts because that's totally cool. So even if the verdict is irreconcilable with itself, the U.S. Supreme Court, that's totally fine.
Yeah.
So you could have a felony murder conviction, and also the jury acquits you of the underlying felony, and the U.S. Supreme Court's like, that's cool. So, for whatever it's worth, just FYI.
Well, breaking news: Travis Kelce is not retiring. In case anybody cares, he's decided he can't go out like that, and so he's going to stick around for another season. In case anybody wanted to break that news in the chat, I'll break it for you. Okay, moving on. Had the Commonwealth produced the exculpatory footage and exculpatory statements to which Ms. Reed was constitutionally and statutorily entitled, the result of the trial may very well have been different. Instead, the Commonwealth engaged in repeated instances of withholding exculpatory information from the defense in a concerted effort to undermine the defense's ability to effectively confront and cross-examine the Commonwealth's seminal witnesses in this case, including Sergeant Buchanan, McCabe, and Higgins. I mean, there it is. Moreover, the Commonwealth's continued piecemeal production of exculpatory video footage, which has by definition been in the Commonwealth's possession since January 29th, 2022, is a flagrant violation of the Commonwealth's constitutional and statutory obligations under Rule 14 and Brady. It is well established that suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution.
Correct.
And that's Brady.
Yep. 1963. 60 years old.
Yeah. Before either one of us was born, I would venture to guess.
Yep.
The Commonwealth may not withhold such evidence from the defense. To do so is not only a discovery violation under Rule 14, but also a constitutional violation. Furthermore, the Commonwealth's gamesmanship in withholding the exculpatory video surveillance footage from the Canton PD and failing to properly preserve this exculpatory evidence has irreparably harmed Ms. Reed. To this day, the Commonwealth has not produced all of the video surveillance footage recorded at the Canton PD on January 29th, 2022. Numerous camera angles and large swaths of time are missing. There's still more. There's still more. And the judge just ruled they don't need to give you the metadata. They can just click and drag it and just hand you maybe a flash drive or something. I don't even know. Like, that's enough. You don't need the metadata because there's still more video out there. And Hank Brennan said in open court, and this blew my mind. I couldn't even believe it. He said, yeah, well, it's out there and I haven't even looked at it. I haven't inventoried it. I don't even know what's on it. I'm sorry. What? You know it exists on this retired detective's hard drive. First, it was an iCloud. Then it was a hard drive. The retired detective just happened to be at the Canton PD when you went there to check it out, but you didn't look at the video. You didn't look at it. So there may be some video in there that shows that the taillight was not shattered when it arrived at Canton PD Sally Port, and you didn't even look. Dude, what are we doing here? As a result of the Commonwealth's failure to appropriately image and preserve this evidence, video surveillance footage, which should have captured the condition of Ms. Reed's right rear taillight at the time it was taken into police custody from multiple cameras at multiple angles, has now been destroyed forever. I mean, that's a spoliation motion that can never be rectified. A spoliation issue, I should say.
You say they're destroyed forever, but as we're continuing to discover new evidence and new servers, who knows?
True. Maybe it'll just appear. Maybe we can manifest it into existence. Absent the destruction of this evidence, which has been in the possession of the Commonwealth and its agents since January 29th of 2022, the defense would have conclusive evidence that Ms. Reed's taillight was cracked, not shattered, when it arrived at the conflicted Canton PD on January 29th, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dighton police officer Sergeant Barros testified he observed earlier that day, he did. After the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, that evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth.
Yeah, but what was it, 47, or was it 0, or was it, 6, or was it? I don't forget all the numbers of how the numbers just kept changing. We
don't really know because there were no logs about what time it was found, where it was found, no measurements, no. And then, in the weeks following, as the snow melted, Yuri Buchanan told his guys, just shoot by 34 on your way to and fro in case anything magically reveals itself. And it did. It
But they had
revealed
leaf
itself.
blowers. They had leaf blowers.
But you had to wait until the snow melted because, snow. And then, so his guys found it. The chief of police, who just passed away, also found a big, giant piece. And who didn't find any of the pieces? The people who actually live at 34 Fairview. They didn't find any pieces. No, they didn't. But none of those pieces were really photographed or documented
or anything. That was good. We don't know where they were, which is fun too, because then of course when they're trying to determine the angle of impact based on where the taillights pieces are located, since you have no frame of reference, it's like okay, that doesn't really work. I mean, you can average a scatter plot, but it would really help to know where the data is. Otherwise you're averaging what? Guesses and wishes.
Oh, well, they're calling it a debris field now. It's a debris field. It's a debris field with no photographs. Or they took some photos, but they lost the camera. No measurements. No little evidence markers.
Photograph.
No.
Look, it makes me laugh.
Yeah. They don't even know. Nickelback. A Nickelback reference. Is that Nickelback?
Yeah.
It is. I'm going to say it. And this might not be a popular thing. But I kind of do like Nickelback. I know I'm going to get roasted for it. I don't care. It's part of the soundtrack of my life. Kill me. Remember who said kill me on the stand? Kill me.
Yeah, I remember that. Yeah.
It was Garino.
Yeah, that's good.
Now we get to the bolded, italicized print. It should not be lost on this court that the video surveillance was destroyed in the Commonwealth's possession in direct violation of a preservation order. As a result, Ms. Reed is left without the ability to forensically examine the Canton PD's DVR system to determine whether the many random clips produced by the Commonwealth in discovery have been altered, manipulated, or tampered with, and whether other clips may have been destroyed. Which takes us to footnote 6. Unsurprisingly, the Commonwealth is utterly unable to establish any chain of custody for the footage, let alone explain how it came to be inverted. Unlike the other video surveillance obtained by MSP in this case, the Canton PD video surveillance footage was never logged into evidence. There are no reports documenting the recovery of the evidence, and there is no documentation regarding its chain of custody. And as we know,
I'm being punked. There's no way this is real, right?
Ashton Kutcher is here. I see him right behind you.
Yeah.
Right behind you.
I mean, it's very elaborate.
Yeah. Does everyone see that silver? Is that a silver YouTube button behind you?
It is, in fact. Yeah.
Okay. So if you guys are looking at your screen, it's to the right of Kurt's cowboy hat. You will see the 100,000 subscriber silver play button that I am trying to get. So if everyone who's here who is not subscribed, it's free. Just hit the subscribe button because I don't know how many subs I'm up to now. Like 77.1, 77,000.1. And I really think that I need one of those silver play buttons. So help a girl out, There's like 8,974 of you here. And I'm sure some of you are not subscribed. So that'd be really sweet. Appreciate it. Yes. And as we know, the judge just ruled on this motion where they were asking for all of these things, like who touched the video when, where did it come from? And Brennan said, well, we can't invent something that doesn't exist. And even Judge Cannoni said, are you suggesting, Ms. Little, that they just invent something that doesn't exist? And then she denied the motion. Said, yeah, you get what you get and you don't get upset. Like we're in preschool.
Well, slightly more the point, I'm suggesting that it can't be authenticated.
Yes. Yes. And what I was suggesting also is, okay, if you're not going to require them to produce it, then we need an evidentiary hearing and we're going to call every single one of these mofos to the stand and we're going to ask them where they got it and who touched it. And Adam Lally is going to be one of those witnesses, as is ADA McLaughlin, right? Because they came into possession of that because they're the ones who introduced it into trial. So let's work backwards. Okay, Mr. Lally, where did you get it from? You got it from McLaughlin? Okay, Ms. McLaughlin, where did you get it from? And they're going to have to go back to wherever they got it from if this case does not get dismissed, which I think it should, but who knows what's going to happen here. Every day is like a new day. The Commonwealth's failure to preserve and produce this exculpatory evidence, which includes the destruction of all original and native video surveillance footage and the accompanying log files, has irreparably harmed Ms. Reed. There is no lesser sanction that can cure the Commonwealth's failures to preserve this evidence. Exclusion of the video surveillance footage at trial would undermine Ms. Reed's defense because the footage itself is exculpatory. Indeed, the very nature of the evidence is such that its exclusion harms rather than helps Ms. Reed. That's right, because they would want it in. So that sanction doesn't do anything to punish the prosecution. The exculpatory evidence to which Ms. Reed is constitutionally entitled is permanently lost. Therefore, the Commonwealth's misconduct can be remedied only by a dismissal of the case. I mean, it's kind of hard to see the other side of that. If you can see the other side of that, let me know.
I mean, sort of the only thing that you could sort of really say in counter is that the nature of the problem is not so severe as to warrant such a strong sanction. Because obviously any sanction the court would give needs to be tied to both the severity of the thing that you're dealing with plus any bad behavior they've done in the past. And you want to typically have a process where you are, escalating in a relatively linear fashion before you sort of reach the more dramatic remedies. You don't really want to skip to the end of the page. So the only sort of immediate counter consideration that comes to my mind is there a lesser sanction that would somehow remediate this in some way? I don't know what that is, but that's the first thought that comes to mind.
Well, that's part of the analysis and the appellate issues, right? Alternatives. Did the judge consider alternatives to declaring a mistrial, right? Here, in this case, there was a motion to dismiss made pre-trial, pre-first persecution for, a lot of improper evidence that was introduced in front of the grand jury. So there's already been a motion to dismiss. It's already been denied. There's a motion to recuse. That was denied. There's been a motion to disqualify Michael Marcy as the district attorney. That was denied. So there is a pattern of conduct here, which is not necessarily set forth in this motion, but the judge is well aware of it because she's ruled on all the other motions.
Yeah, and also it's just slightly also differently because when I was answering, I was considering it in isolation.
Right.
Like also problematic for me is not just that one thing unto itself, which, whatever, I suppose, as far as that goes, but all the other problems in the case, which, you and I are well aware of, the evidentiary problems, lack of logs, the way that things were handled, deleted evidence, phone records being destroyed, phones being tossed in dumpsters, phone search records being deleted, and it just goes on. And the lab, they didn't even bother to label which cup it was coming from. They didn't bother to record who dropped it off at the lab. That's not important anyway. It's just like it's just the pile more than anything else. So
they never swabbed the injuries to John O'Keefe's right arm.
Right, exactly.
Them trying to strong arm the medical examiner into changing her testimony, changing the death certificate from undetermined to homicide, and then saying, rookie move, you should have had me and the other guy do it because we do it all the time. The calling the medical examiner a whack job C word, all of Proctor's text messaging, all of the improper shenanigans that went on, like the totality of the circumstances here would indicate to
so that would more lean me towards the dismissal, right? It's not just the one thing. It's like it's all these little problems, which unto themselves, maybe each one of them can be somewhat look the other way on, but like when you add them all up, it's like just how much largesse do you really want me to extend you, man? There's limits, man. Jeez. How
about the fact that they hid the dog? They hid the dog.
Oh, yes, Chloe.
And then Nicole Alberts on the stand is like, I know where Chloe is.
Oh, and did I understand properly from the motion that they've actually now seen the dog and there's been dog bite?
Yeah, they did some molds.
Things taken in January. BS. I demand proof of life. I want to see Chloe with a copy of USA Today. I demand proof of life.
Yes. How do we know who cares? Because their expert is not a medical doctor. And she ruled in the first trial, only a medical doctor can opine as to the cause of injuries. That's why Rentschler couldn't testify to all his biomechanical proof that his injuries couldn't come from a car. And this guy that they have, he's a canine behaviorist.
I don't know why you need to necessarily be a doctor for that. I don't know that a doctor would necessarily make you particularly educated in what caused the wound in particular, as opposed to what do I do about it now? Well, that's what doctors worry about. It's like, geez, I can't help noticing there's this gash in this person. What do I do about it? They're kind of not really necessarily concerned with how did it happen, as opposed to how do I fix it? So,
but I think that a doctor is more qualified to opine as to dog bite injuries, a doctor who's treated thousands of them, as opposed to a guy
the
who
nature,
doesn't have a medical
yeah,
degree.
yeah, the nature of the expertise there is from the exposure to the dog bite wounds and in the
Right.
practice, right? So it's not based on them being doctor really as such. It's based on the fact that due to their exposure, they know what dog bite wounds look like. But then someone who doesn't necessarily have an MD should be able to gain the experience through other channels. So shouldn't necessarily be exclusive to an MD, but that's just me.
Well, Rentschler wanted to testify that the head injuries to John O'Keefe did not come from his head being hit by the car, and she wouldn't allow that. So
yeah, that seems odd to me. I don't necessarily think an MD would necessarily be qualified to make that determination, and I don't think that someone who isn't an MD wouldn't necessarily be qualified because you're just like, it goes into other disciplines.
But because she ruled that way during
right, the
this
inconsistency
trial,
is the problem. The
she has to
inconsistency is the problem.
Stick with her own ruling. She can't. I mean,
one would imagine she
Yeah.
has to have consistency, but has that really been her trademark so far? So okay.
Yeah, no, she's new trial, new rules, it's a new day, it's a whole new day, new evidence. Who knows what else is going to reveal itself? All right, let's see if we can wrap this. And we have a lot of questions. B, even if this court disagrees that Ms. Reed has been irreparably harmed, the Commonwealth's misconduct gives rise to presumptive prejudice that warrants dismissal. Misconduct by the Commonwealth in this case was egregious, deliberate, and intentional. These were not innocent mistakes. The repeated and flagrant discovery violations engaged by the Commonwealth and its agents were intentional and designed to bring about a wrongful conviction. Here at trial, ADA Lally, the Commonwealth, and its agents intentionally withheld video surveillance footage from January 29th, 2022. The Commonwealth sprung inverted surveillance footage on the defense in the middle of trial in violation of Rule 14, as well as its certificate of compliance, and then it compounded the violations by attempting to perpetrate a fraud on this court and the jury. By knowingly eliciting false testimony from Sergeant Buchanan on direct examination, the Commonwealth violated the ethical prohibition against presenting knowingly false evidence to the trier of fact. The inverted footage of Ms. Reed's vehicle from this interior Sallyport camera was an unquestionably a false account of the true facts. And the Commonwealth passed it off as an accurate depiction of the SUV when it arrived at the Canton PD on January 29th, 2022. And that, quote, as seen in the video, no law enforcement officer approached the right rear taillight. The Commonwealth's deliberate attempt to use discovery violations to its advantage in an effort to perpetrate a fraud on the jury is the precise type of conduct that requires dismissal. Moreover, both ADA Lally and ADA McLaughlin were caught withholding exculpatory information from the defense at the first trial. Ooh, that might be in drama. The Commonwealth's underhanded decision to surreptitiously reveal impeachment evidence to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a gross violation of the Commonwealth's constitutional obligations under Brady and its progeny. Even after trial, ADA Brennan located exculpatory video surveillance footage, which was withheld from the defense at the first trial, and established that Higgins made a phone call at 1:35 a.m. outside the Canton PD. This exculpatory impeachment material was never turned over to the defense, and then something is redacted. The Commonwealth's repeated violations of its constitutional and statutory discovery obligations were calculated and intentional, and were done in an effort to secure a conviction at all costs rather than pursue the truth. Are you crying over there because of the injustices that we're reading about, Kurt? I'm going to send you some eye drops. Indeed, as discussed above, the Commonwealth, the Commonwealth's misconduct has resulted in a violation of Ms. Reed's constitutional rights so as to give rise to presumptive prejudice. The discovery violations in this case constitute a Brady violation and thus violate Ms. Reed's due process rights. Quote, to establish a violation of the rule of Brady v. Maryland, as incorporated into Rule 14, the defendant must demonstrate upon review that evidence actually existed, that evidence would have tended to exculpate him, and that the Commonwealth failed to disclose it upon proper request. As discussed above in Part 2A, all three prongs of the Brady inquiry are met in this case. Given that these facts give rise to presumptive prejudice and considering the need to create a climate adverse to repetition of that misconduct, this case should be dismissed. To allow this case to proceed to trial would create a climate in which these types of flagrant constitutional and statutory violations are regarded as permissible. Such an outcome cannot be tolerated by this court. The Commonwealth's clear, repeated, and intentional failure to comply with discovery orders requires an appropriate remedy in this case. Because the discovery violations concern a failure to produce and preserve exculpatory evidence, and because the exclusion cannot remedy the violation, the only appropriate remedy is dismissal of the case. Because the Commonwealth's egregious misconduct, including repeated and intentional delays in providing discovery, the withholding of material and exculpatory evidence, and failure to comply with court orders regarding discovery, Ms. Reed's constitutional right to a fair trial has been irreparably and irreversibly harmed. No proceeding against her can satisfy the constitutional requirements of a fair trial. The defendant therefore respectfully requests this honorable court to order that the case be dismissed with prejudice. C. Dismissal is the only appropriate remedy for the violation of Ms. Reed's Sixth Amendment right to trial by an impartial jury. Additionally, dismissal of this case is also required to remedy the violation of Ms. Reed's Sixth Amendment right to an impartial jury. And then everything for the rest of this page is redacted.
Yeah, does this have to do? Does it have to do with the trooper who supervised the jury? Maybe.
Oh yes, yes, Fanning. Good, good. This might have to do with Fanning being in charge of the jury. All redacted. The rest of page 31.
Which I don't know why that would be redacted, but okay. Obviously, it seems almost impossible that that would come as a result of any federal whatever.
Because the defense didn't even know about it until 10 minutes before their closing. So
yeah,
I don't know.
Nice. That's a nice touch.
But who knows if the feds started digging into that after? That could be currently ongoing. Interesting. All redacted until middle of page, whatever this is, 32. Notably, a juror may never be dismissed because of their views on the case or for reasons having to do with their relationships with other jurors. Instead, jurors may only be dismissed for reasons personal to the juror that have nothing to do with those views on the case or relationships with other jurors. You know what? I pointed this out and I said, there were 3 jurors that were very pro Karen Reed that were dismissed. One of them was dismissed before deliberations based on Fanning's communications to Fanning told the judge that juror had been overheard in a bar talking about the case. That juror was dismissed. It was a female. I said, maybe she's angry. She may have gone to the feds. She may have gone to the defense. She may have gone to someone to talk about Fanning's involvement with the jury after that news broke. Who knows? Other jurors may have come forward to talk about Fanning's involvement with the jury, and this may be redacted because they're trying to protect those jurors. That's another thing that it could be about, perhaps, because the jurors are in fear for their life, understandably so. Dismissing a juror because of their views violates a defendant's Sixth Amendment right to an impartial jury. And then there are some more cases cited and some more redactions. Jury tampering such as this is presumptively prejudicial. The Remmer v. United States, 1954 case, and triggers a burden on the government to prove that the tampering was harmless to the defendant. Oh yeah, that's what it's about, jury tampering. Therefore, that judicial immunity issue could, if in her administrative duties as the administrative justice of this county, she assigned Fanning to oversee the jury, that may nullify her judicial immunity. I don't know. I gave you the stuff. I didn't look at it yet. The Commonwealth cannot do so here. Something else is redacted. As per Massachusetts law, courts do have the discretion to dismiss jurors when doing so would be in the best interest of justice. Judges can do this at any time during the trial process, although the procedural burden and standard vary at various stages. Post-impanelment, but pre-deliberation, if a judge is alerted to potential misconduct of or affecting jurors, the judge first determines whether the material raises serious questions of possible prejudice. If she so determines, she must then hold a hearing to inquire further into the alleged misconduct. Well, she didn't do that here. She didn't hold a hearing about it as far as I know. And there's a whole bunch of more redactions to the end of page 33 and all the way till mid page 34. Ultimately, Ms. Reed's Sixth Amendment right to an impartial jury entitles her to certain procedural protections when it comes to the dismissal of jurors. Those procedural protections were not provided here. There was no hearing. These constitutional violations, along with the egregious discovery violations discussed above, demonstrate the inherent unfairness of the proceedings against Ms. Reed and warrant dismissal of the case against her.
Yeah, too much missing information for me to provide really any meaningful opinion. I guess I will note that violation of Massachusetts rules does not make a violation of the Sixth Amendment, because obviously the rules can't control the Sixth Amendment. So if they violate the rules, that does not mean there was a constitutional violation. You'd want more specific federal authority for that proposition.
Okay, but it's hard because so much of that is redacted that we really don't even know.
Exactly. So I don't know what they have. So it made it really hard for me to provide an opinion.
But if this is denied, you can bet that it will go up on appeal. And I find this to be a much more interesting appellate issue in some cases than the double jeopardy issue. I don't know, maybe. Just because I've been talking about the double jeopardy issue to death. Although, in my opinion, double jeopardy is a really, really important part of the Constitution. So
it is important,
right,
but of course, trying to figure out exactly what it means is the challenge, right?
Yeah.
That's where the fun comes in.
Conclusion. Oh, we're at the conclusion. For the above reasons, Ms. Reed respectfully requests that this honorable court grant defendants' motion to dismiss for extraordinary governmental misconduct with prejudice. Although dismissal is required and appropriate under these circumstances, in the alternative, the defense seeks and it is entitled to an evidentiary hearing on these issues attendant to the Brady violations and juror interference. So it's juror interference. That's redacted there. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ADA McLaughlin, ADA Brennan, Lieutenant Tully, Chief Rafferty, who is the chief of the Canton PD, Trooper Proctor, Sergeant Buchanan, Colleen Crawford, other members of the Canton PD, and Lieutenant Fanning, who now we know is in charge of the jury. So here, dismiss the case. Otherwise, all these people are coming in to testify. XOXO, Alan Jackson, Elizabeth Little, David Giannetti, Robert Alessi, dated February 21.
They all sign them. They all sign them personally. That's nice. Usually you just have one signature. That's nice.
I know. They all do. They all sign it because they're good like that. Wow. Just wow. Sorry, guys, but we're not going to get to that Brian Walsh the Brian Walsh Zoom hearing today. I'm real sorry, but this has to take precedent over that today. So many questions. I just want to keep you here for a couple minutes and see if any of these questions are applicable to you, that you specifically can answer.
Either way. I'm having a fun time.
Oh, good. I'm glad you're having a fun time. Tracy Walker is here, and she is so super generous, Kurt, that if she comes and if she likes you and comes watches your channel, she's gifted like hundreds of memberships in the past couple of streams. She's new to the channel as far as I know, but Tracy Walker is rocking it. Thank you, Tracy, so much. And to those randomly gifted, Kelly, if Chloe bit, you must have quit, says, I do designs. I'd love to make some for you. Awesome. Shoot me an email. My email is in the channel description. Jamie Chambers, thanks for the 10. Should we expect a decision from Auntie Bev regarding Alan Jackson before Tuesday?
I would think it's more likely that she's going to delay any decision just for if you want to go to nefarious realpolitik reasons to prevent the defense from having more time to adjust to it.
Yeah.
So
yeah, but also if she wants this drop dead date of April 1st to really go ahead, she'd have to rule sooner than later. But also, were they even finished with their arguments? She kind of cut it off in a weird place. I think they all had finished with their arguments. But she said we're coming back, and I can't remember because I didn't watch the end of the hearing for a second time. But the answer is I don't know, Jamie. I don't know. I don't think you should expect it. Commonwealth of Massachusetts, thanks for the 10. Even if not successful, the habeas will still further flush out the record, as well as continue to place a magnifying glass on every decision and action made in this case. How could that affect 2.0?
I mean, it really won't flush out the record because all the facts are locked. This is a straight issue of law. No matter how you read the various cases, in any case, the federal court is required to take the facts that are presented to them. So there's not going to be any expansion of the record. We're on just pure issues of law, which is what I like. That's what I typically cover is appellate arguments, because issues of law are best. It's all just game. It's all just chess in your head. And it's fun.
And you take the emotion out of it, whereas I get so worked up about this that I'm focused on the facts, you're focused on the law. So that's why
it's like just tell me what the facts are. because facts are messy. We got witnesses, and I got to determine credibility. It's too messy, man. Just tell me the facts. Let me figure out the law, man. That's where I want to live.
And this is the difference between a trial lawyer and an appellate lawyer. Because Andrea Burkhart is the same way. You know, she works on papers. She works on the facts are already there. She doesn't have to figure out the fact, like she says a lot, and you do. It's like, we already have a set of facts. Now we got to talk about the law. So there you go. Angela Waves, thank you for your $20 super sticker. You're the greatest. KLM says 147 pages redacted copies out. Thank you so much. You were the one who alerted me first. And we got it. And we did it. On top. Thank you for being on top of the super sticker, as always. Michelle, MPF didn't give defense an option to object, in my opinion. Also, maybe the defense was waiting for the judge to proceed. She made it known it's her court. Possibility. Thanks, Michelle. Thrift with Joey, what might have happened if the defense had asked to poll the jury? Well, that's the risk that you would run, is that they did convict on one of the counts. And I think I'd want to hightail it out of there. Yeah?
Yeah, I think so. I think if mistrial, that's usually what the defense, that's usually something they want. It strikes me as unlikely the defense would have asked to poll or asked for separate verdicts. So, I mean, we'll never know for sure, but I'm probably not.
Miners Cal, hostile judge towards defense, odds of objecting. Okay, yeah, exactly. She had been a hostile towards them the whole time. Thanks for your super chat. Scott, Kurt, will they review the video? And if they see judicial misconduct, can they also address that immediately? MSP guarding jurors and not court officers.
With respect to the habeas, no. It is a new lawsuit unto itself. There is no record except what is brought into the federal proceedings. And so none of those issues are present in any of the documents. So for the purpose of the federal habeas, they don't exist. So like issues relating to, at least for the moment, right, they don't exist. So issues relating to who supervised the jury or bias or like all those kinds of problems, at the moment they don't exist. It's a specific factual, a specific legal inquiry, and only the facts that are relevant to those inquiries are obviously presented. So that's where we're at.
Right. And then Amy, thanks, Scott. Amy comes in and says, can it be added into the habeas? Like, can they amend the habeas to talk about the jury stuff with Fanning, et cetera?
I suppose hypothetically, but if they knew about it 10 minutes before deliberation, then I don't know why they didn't put it into the original petition.
Right.
So I don't know why they'd add it now. It doesn't make any sense.
Well, would they have to have a motion denied on that basis first, or can they bring a completely new issue up?
I mean, they could try to amend their proceed. They could try to file a motion to amend.
Thanks, Amy. Inverted and altered. The timeline was not inverted. I don't know. The timestamp, I think, was a different color. I don't know. They didn't really address that. Or it was redacted and we couldn't see it. But thank you for your super chat. Nelly, question. Can Karen present a cumulative error bias argument of all instances of judiciary bias, including Trooper Fanning, juror dismissals, et cetera?
Eventually, if she's convicted, she can raise those issues as errors. Sure.
Yeah. Greg says, just joined. Is this the motion to dismiss or the habeas? Well, first we talked about the habeas and we talked about some case law, and then the story broke that the redacted copy of the motion to dismiss was out, and we did that next. Thanks, Greg. Chloe Albert's Revenge. If we have a redaction problem, the usernames in here are fire. Just take the docs down to Fulton County, Georgia. Those ADAs will have the witness read everything into the record and trigger a mistrial with a 4-hour turnaround time. Was that Fonnie Willis? Was that the Fonnie Willis or something else in Fulton County, Georgia? Or was that
that trial that went on forever with the young
the YSL
trial? Yeah, YSL trial. That trial was messed up. Yeah, one of the things is like with Karen Reed is like it can always get worse, right? We were talking about this as we were talking about the Supreme Court case Glossop that the U.S. Supreme Court just decided. Like the facts on that are arguably much worse than Karen Reed. So there's some comfort somewhere in knowing it can always get worse.
Right. 20th Century Fox says, I'm so happy to see the two of you together. Thank you. Borders Girl, only thing surprising me these days is the increasing audacity of the Commonwealth. It knows no bounds. Michelle, just this piece of information is enough, in my opinion, to dismiss. That was at 12:15, so I'm not exactly sure what you were talking about. Chloe Albert's Revenge, left is right, right is left. It's like a Twix. We love you, Kurt, says Glow T. Thanks.
Thank you. Love you guys too.
Tracy Walker gifted another 5 memberships. Told you, you're going to see your name a lot. Thank you, Tracy. Lucci, thanks, says, hey, Mel, on the topic of phones, the Truth and Transparency just had a live showing Jen phone and watch move separately that morning. Oh, thanks for the deets. Haven't seen it. Thanks for tuning in, though, from I think South Africa. Samantha Jones is here. Sex in the City. Kim Cattrall, love it. Thanks for your super sticker. Random Thoughts, thank you for your 50. May I ask a probably stupid question? There are no stupid questions. Random Thoughts. Why do they redact statements of the flow of the motion? Will it not give us a slanted view of the whole of the basis and reason of the motion? Do they not realize it will lead to assumptions and speculation? Well, we try not to assume or speculate here, but those are things that are under federal protective order, and so they have to redact them. That's my understanding. Kurt?
Yeah, I mean, I wouldn't really personally worry about it too much if I were drafting a motion, not for at
Mhm.
least reasons I might not necessarily be 100% clear as I'm drafting it, what will need to be redacted or not. So I'm just going to try to put it in the order and flow that makes the most sense when it's read in the unredacted form, and let be what will be. Because, you know, ultimately, of course, my audience is the judge. So I'm writing to them. So
And when they orally argue this in open court, they're probably going to talk about some of the stuff that's redacted if they can. And so we'll learn about it then. Also, it's not a stupid question. It's a good question, but I'm just happy that we got a redacted copy of this motion because I thought it was going to be impounded forever and we were going to get nothing. So thank you so much for the 50. Chloe Albert's Revenge. To Jen McCabe's credit, her workout video, the Canton butt dial lift, is doing great online. Well done. Sage is here. Will the redacted parts become public at the motion to dismiss hearing next week, or will it all be a secret? Like, yeah, they may talk about it. They may, if they can. Great question. Thanks, Sage. And if this is denied, can they appeal before the trial?
the motion to dismiss, no, they can't appeal that. If they try to exclude Jackson or Arca, maybe, although that seems extraordinary, but possible, I suppose.
Yeah. Gotta wait and see. Hi, Lucci. Jen's phone was at the bottom floor, an iPhone on her arm. Her husband, Matt, had access to her phone. What if he did it? Truth and Transparency had presentations about the steps on phone and watch. They moved separately. Jen and Matt is liars. Well, I don't know. I haven't seen that. So I cannot confirm or deny the truth of that other creator's video, but thank you so much for your super chat. Rainy Day. What do you think ADA McLaughlin had to do with a lot of the nefarious acts regarding discovery, et cetera? I have a hunch she's more involved than anyone suspects. Just my feeling, no facts to support. She didn't say much during the trial. I think she objected once. I think we heard her speak at one hearing that had to do with something about some media motion. It was like Boston Globe or Gretchen Voss's attorney. She handled that motion. But aside from that, I don't know. Pro Gamer, it's Sue Candell. Feds weren't targeting Karen Reed's case. FBI may still be investigating. The DA, MSP, CP, they concluded not guilty and provided the evidence. Thank you. I don't know Sue Candell, but
I will note, just as a general proposition, the feds tend to be very small c conservative on bringing charges. They tend to only bring charges when they have it 5 different ways. They don't like to be embarrassed. So, their lack of ability to prosecute doesn't mean that they didn't find them not guilty. It just means they weren't able to satisfy themselves to their somewhat exacting standards that they could, win this. So, for whatever it's worth, it's not quite the same thing.
right. I think everyone was expecting other people to be arrested at the end of their investigation. We don't even know if it's really over, but the unfortunate part about that for me is
the feds don't like to play.
Yeah, there will never be justice for John O'Keefe if the real perpetrators are not found out. Luna's mom, it could have been a total accident. He could have walked out of the car, slipped on the ground, smashed his head on, the concrete. Like, we don't know. It didn't come from a car. I'm not accusing anyone of anything. Luna's mom, will the redacted parts be discussed in open court or at sidebar? Again, don't know. Thank you for your super chat. Kelly, what are the odds that there's a lot of blackmail going on in Canton? In my opinion, Judge Bev included. And speculate to that, Kelly, but thank you for your thoughts. Amy, Hank hates the feds, and I think that's why he took the case. He basically stated that the defense has a murky relationship with AJ. Thoughts? I don't know. I don't know. Did he say that recently, or was that when he was representing Whitey Bulger?
Whitey Bulger, yeah. So that would be why I would hate the feds from that exposure. Yeah.
Could be. Nick, can't a due process argument be made with regard to partial verdicts and requiring an all or nothing be a due process violation regardless of a rule?
I mean, possibly. I mean, obviously, that argument isn't being made right now. More to the point, equal protection, I suppose, because the judge can do it for some people and not others. So that could potentially present an equal protection problem. But I'm just simply unaware of any federal law anywhere that, or case that says anything like that. It's not an invalid idea. I just don't know of any support for that proposition right now.
Okay, thank you. Thanks, Nick. Charlotte, Bev could claim Arca was nefariously colluding with AJ. She's that hostile to AJ. Anyone associated with him is deemed toxic. Here's the stupidity of her ruling that way. And Hank Brennan's assertions that, they were in collusion. They clearly he was biased, and they were. Every expert witness that I hire to come in and testify on behalf of my clients has an opinion that I agree with. Otherwise, I wouldn't call them. Couldn't you say that about every expert witness? The point is that Alan Jackson and the defense did not hire them to do the accident reconstruction report.
Yeah, I have like an even more principled question on this. If ARCA is biased to the Commonwealth, just exactly what does non-biased even look like in principle? What does that look like?
Right. No,
I don't know.
That, I mean, I see what you're saying, Charlotte, and I would see an asinine ruling like that, but it's like, they're not, just because they agree with your theory of the case does not make them biased. It's based on science, physics, and collusion. Could you imagine they're colluding? Like he was sitting around on a Sunday when he's going to be putting him up on the stand on Monday, and he's waiting for Daniel Wolf to send him questions. No, he doesn't need. It's just the whole thing is so ridiculous that I can't believe it's being made into such an enormous deal. And the fact that they mailed them a bill out of the blue, and then they wound up paying it after the trial was over. Like, okay, they turned it over to you. There's no prejudice in this trial. I don't know. I'm just really not seeing. That's a whole issue for a whole other day. Sunday Girl, did the federal investigators have the new Sallyport evidence? If they didn't, could it have affected their investigation? I
don't know.
They probably didn't. I don't know. It's a great question, but I don't know what they had, Sunday Girl. Thanks. Britt, whenever I'm having a bad day or feeling low, I watch Uncivil Laws, Trooper Paul videos, and it brightens my day. Thank you, kind sir.
I enjoyed making videos about that trial, man. There was so much. It's just like, wow, it was fun.
Thanks, Britt. Chloe Albert's Revenge. Rules of evidence are like red lights. They're just suggestions.
That's funny. Good one.
Or stop signs. Glamasu's, just for the awesome snark, making me laugh my tail light off. Tail light. I said tail light. Thanks, Suze. Amara, Kurt and Melanie are making me giggle, snort out loud at work right now. I'm not gonna lie, I'm living for this vibe. Vibes are on, man. Vibes are on. Suze, Newton's laws apply in Canton. They do or they don't. On top, refraction of light theory. Thank you. Breenan's proofreader. The new video also shows that they had time to drive 4 minutes to 34 Fairview to sprinkle evidence and get back for their starring role in Sallyport Take 2. Yeah, because the car would have arrived earlier. If at first it was backed in, you would have, yeah, well done. Well done. Thank you, the advocate, for becoming a new member. Marvin, sanctions may include the exclusion of evidence. I can already hear Judge Canoni. Let's exclude the exculpatory evidence. Thank you for your super chat. Dr. Russell is the GOAT is here from Norway. Says, in my opinion, Judge Bev treats the parties like she's a parent with a golden child, the Commonwealth, and a black sheep child, the defense. She kind of does. You're kind of right. Jury on Turtle Boy, 2 people there, 1 dead, 1 guilty. Yeah, that's what they said. This juror said, a lot of the jurors thought that just because, they were both in the same place at the same time and they were both there and then one is dead, that she must have done something.
Yeah, that's wild. That's great thinking. Good work. I suppose if I told the jury post hoc ergo propter hoc, that wouldn't really help, right?
Yeah.
Okay.
Say that again. I didn't hear you said. I'm sorry.
Post hoc ergo propter hoc. After that, therefore, because of it, because the one thing happened after the other, the first thing must have caused the other.
Right.
Or to put it another way, correlation is not causation.
How about Ipsy Dixit? Because he said so. That's my newest favorite Latin phrase. Where did you get the mug? I don't recall where I got this mug. Where you can find a lot of this stuff is on Etsy. Check Etsy. There's tons of really, really good merch there too. But, buy my I Went to Melanie Little with Cancun merch if you want to, because that's pretty funny. And if you know, you know. Peppermint, Melanie and Kurt, you two are the embodiment of forgiveness and cooperation. I like seeing you together on screen after some conflict in the past. We never really had any conflict in the past. We just disagree on certain cases. We've never had beef, right? People
we've
were
never had beef.
interpreting this beef that we had, and it just didn't exist. We were always talking. We're good. Thank you, Peppermint. I appreciate you.
But I think it was a lot my fault, and I do apologize because I never wanted to start beef, and I was never trying to troll. It wasn't really what I was trying to do, but that was the end effect of some of what I was doing, and I apologize because it,
you can't control the
it didn't really happen, and I'm so for whatever part I played in, and I'm sorry.
I accept your apology.
Please forgive me.
I accept your apology. Chat, please forgive him. Bygones. Vanessa, coincidence, motion to dismiss made public on 2/27. Haas long before the motion to dismiss is ruled on. Haas long it will. They're going to have to, according to that scheduling order, I don't have the dates in front of me of when their opposition is due, the Commonwealth. And then, of course, there will be a hearing. I don't have that schedule right in front of me. Somebody in the chat might have it. And you might have it at your fingertips better than I. Thank you, Vanessa. Laura Notcroft, does it matter if Hank at the time believed what he was saying is true? Double down came across that way to me, unless he wasn't at 1.0, yet he understands the transcripts or checks with co-counsel. I mean, he had a whole buildup to, we got this from the feds. Like, I don't think he believed what he was saying is true. And then really, it's not an excuse. Ignorance is not an excuse. He made misrepresentations to the court when he got up and said, after his whole entire monologue, and we had to get this from the feds. I was like, you got it from the defense.
Yeah.
The defense gave it to you.
The fact that the defense turned over emails to ARCA, though, still slightly blows my mind. It's work product. It's like you'd have to claw those emails on my cold, dead hands.
Yeah. Well, there's no journalistic privilege in Massachusetts, so is there really a work product doctrine?
I thought attorney-client privilege was still a thing, yeah. So I thought so, but okay.
I thought.
All right.
Piney Woods, it's so nice to hear two learned counsels say what is in my head. Well, we're happy to oblige. Thanks so much for all you both do. Good to know I'm not crazy. This case is wrong. Thanks for your 20. Kay Willis is here. She's a realtor south of Boston for all your real estate needs, and she has gifted 5 memberships. Thanks, Kay.
Why would I want to move to Boston? Oh, well.
Do you? You want to move to Boston?
No, I was like, why would I want to move to Boston given what we know about Massachusetts, though? I'm just saying, man.
I know.
I'm sorry,
she's always gifting, so I figure shout her out. It's okay. Edward, Yuri on direct explicitly identifies himself and Proctor as standing in specific spots. On cross, he does not know who was standing where. I remember that. Breenan's pants on fire. So excited. I just purchased the new free read shirt in your store and it strains credulity. Thank you. Thank you. Jason, can either of you explain how denying the defense metadata from the videos is anything but obfuscation?
The only way it makes any sense is that the defense should have been aware that metadata exists in principle, because it's pretty hard to have data without metadata. And to the extent that they agreed on a process and that process did not give them the metadata they wanted, then additional disclosure from the prosecution would be unduly burdensome because the defense had a fair opportunity to get it in the first place. So that's the only way it makes sense from first principles.
Yeah, except for that's not what happened. Because they sent the guy to the Sally Port. He was not allowed to examine anything. It just didn't exist. And now they're telling them, first they said that this new video was on an iCloud and then it's on a hard drive. And so they didn't really have the opportunity to get the metadata because the Commonwealth didn't preserve it.
Yeah.
So she's not saying you can't have it. I think they're saying it doesn't exist. So it's whack. The whole thing is whack, Jason. You know that. GV, I thoroughly enjoy you two together. Perfect balance of emotion and law. Oh, thanks. Please consider doing more shows this way. Honorable mention to Uncivil's impeccable humor. Chef Kiss. And yes, YSL holds the most ducked up spot. The number one.
Yeah.
Thank you, Jazia, for thanking us for the collab. What state does Kurt practice?
I am licensed to both Virginia and Texas, where I currently live, as you can see from my flag on my
Oh, Virginia, Texas, and the U.S. Supreme Court.
And of course, the U.S. Supreme Court. Yeah, that's my license for Supreme Court right there.
Jim Girl, if we're all in trouble if she's found guilty and denied upon appeal, what do we do when they start putting who they want on trial with faulty evidence? It happens every day. Cynthia gifted 5 memberships. Thank you, Cynthia. And she 3PO became a member. Welcome. Parachutes and pirouettes. Thanks for going over both these motions. Can Mr. Brennan be in trouble for lying to the court?
In principle, sure, but the judge seems to be willing to be much more forgiving to the prosecution than the defense.
Which is wild to me. I mean, and it was all pointed out by Alessi very methodically. I thought that was really a very well done
I was satisfied.
Argument, you know, and it was he gave her a binder. I mean, everything was printed out for her. It was easy to follow. But she got mad at him when he said, here's what I'm going to do next. And she's like, stop telling me what you're going to do. It's like, girl, take a chill. And is it Bev or someone else that on the motion to dismiss, or if you already discussed, she will be the one to hear it.
Of course.
If that's what you're asking. Yeah.
Yep.
Thank you. Barbara DeLong, thank you so much for your 20, for thanking us. Dr. Russell's the GOAT. Do you think Judge Bev will allow Betero? I don't know. They haven't heard that application yet. Yannetti was told to submit an supplemental affidavit. You know, Brennan got up in open court and said, I don't have any opposition to this, but I just want to, you know, tell you my thoughts.
Yeah, that was very, very irritating. Because I'm putting myself in the mind of the judge. It's like, what do you want me to do? Why are you talking to me? What do you want me to do?
Right.
Well, I don't want you to exclude. Okay, why are you talking to me?
Right. Because he wanted, it was for the media. It was for the media. He was accusing Betero of colluding with the defense and exchanging discovery under protective. Like, it was a clear grandstanding. Dennis the Menace, and the lights all went out in Massachusetts. BGs. Thank you. Cynthia, bias looks like Bev. Thanks for the 10. Michelle, will the feds be involved in the second trial and offer evidence to both sides again? Also, I don't know. I don't know if they have any more to give. If there will be another dump of documents of things that came after their last dump, I don't know. It's a great question. Also, why wasn't the tow truck driver questioned when Proctor took the car? You mean, why did nobody call him to the stand? I don't know. Maybe they couldn't find him. Maybe they didn't know what he was going to say. Cannot speculate because I don't know the exact answer. Greg, Hank knew he was lying about the feds, and if Bev didn't get so mad, he never would have corrected it.
Maybe.
Possibility. If the federal investigation is over, says Sandy B, can't they release the federal findings?
That's not the way the feds work. The FBI conducts investigations. They don't tell you when they're doing it, and they don't tell you when it's over. So they don't really do that. Right.
And if it is over, they don't release their materials, correct?
Yeah.
I mean, look how long it took to get the JFK assassination documents and, you know, the Nixon, I mean, all that kind of stuff. Those are much bigger cases, but it's not like they just open up their coffers and say, here you go, everyone. Here you can see what our investigation revealed, because they're super secret like that. Kaylee Clark, laughing my taillight off. New favorite phrase in this case for me. And I just made that up. Thanks, Kaylee. Hit like and subscribe, everyone. Thank you, Nick Knack. The Goodmans are here and they've gifted a membership. It's a husband and wife, and they try and outdo each other in super chats, and they're so awesome. Thanks, Goodmans. Amber says, what, if anything, does the recent motion denials by Bevs for discovery and metadata have on this misconduct motion relating to discovery motions she originally granted? Thanks, Melanie and Kurt. Well, this is more to do with what happened, I think, after the trial and the inverted video that was admitted during trial. And the only time to make that motion would have been after trial. And the jury tampering issue. These are all newer issues. And so I think they are different in that way. Kurt?
I don't know that it has necessarily any particular impact onto itself. It's just another thing to consider and another piece of the puzzle that the judge could use for potential actions on their part. But, you know, I don't know that the one necessarily bleeds into the other.
Okay. That's what I was thinking too. Good. Thank you. Alessi is smooth as a duck. Thanks for your vibe. Who says, love you two together. This narc is priceless. Thank you. Thank you. Alessi is smooth as a duck. And just here, she's throwing up a hot 10. The thing the Commonwealth won't say out loud is that what this is only complicated because the defense doesn't normally work with the feds, because the prosecutor would probably drop after the report.
Yeah. It's pretty unusual for the feds to approach the defense. Yeah. Normally that's the other way around, right? The prosecution and the feds will work together, or at least in concert with each other. So the fact the feds are working with the defense is pretty notable.
Right. And it's also very unusual that you would not hire an expert that was hired by yourself, but an expert that was hired by the feds that you had to like tiptoe around, and either side could have called them to testify. That was made very, very clear. The Commonwealth did not want to pick up the phone and call them because obviously based on their report, the Commonwealth knew they were not going to say anything in their favor, but they could have, and they didn't. And so that's why it was confusing. And that's why typically when I hire an expert, there's a form letter that goes out. Please send me your engagement letter and your retainer. And quite frankly, I have never hired an expert who didn't require an upfront retainer, that waited to get paid until after, trial and after all that travel. So in that sense, of course it's weird. They did drop mail them a bill. They picked up the phone. They called the attorney, the U.S. Attorney's Office, and said, "What is this bill? Can we pay it?" And they said, "Yeah, you can pay it." So they paid it. Their experts don't work without a retainer up front. And
Experts like to get paid.
And they want to get their money in advance of them showing up too. Look, a surgeon can charge $15,000 a day here to testify at trial. And you better give them that 15 grand 10 days in advance before they cancel all their surgeries for the day that you want them to come in. And guess what? If that day gets adjourned and they got to come in a different day, you're paying again. So, the $23,950 that they paid, first of all, for two experts is not in any way a large amount, quite frankly. And it's pointed out that the line items, while there is something that says trial prep on there, there's no line item for testimony. It's travel. So trial prep does not mean that Alan Jackson prepped each of them for trial. It means that they looked over their reports. They got themselves ready to testify. It does not necessarily mean that Alan Jackson prepped them for the trial. That's like a very important distinction. Ordinarily, I do prep my experts for trial because I'm paying them. I retained them. I hired them to do the job. They didn't do that in this case.
Yeah, I'm calling experts I didn't prep, and I'm not 100% sure what they're going to say. That sounds like fun.
Right. But you have their report. So it's in cement. They can't change their findings. So you can talk to them about their findings. And when they did the voir dire of these crash daddies, as we like to call them, there was a list of 14 items that the feds gave them that they reviewed. So when Brennan gets in there and says, "I have no idea what they reviewed and you got to turn all this over," it's there. It's in the report. Lally didn't do his due diligence, in my opinion, during that voir dire. And that's his problem. That's on him. But yeah, that's a great question. And thanks. I went off on a tangent a little bit. Mama She is here. Great show as always. Thanks, babe. Snacks. Melanie, will you be attending this trial? Love the collab. Let's see if it happens on April 1st. I'm sure I'll be there at least once.
If you go, try to give me a heads up. Maybe I'll try to go with you. It could be fun.
Yeah. Well, you got to get a seat. That's the problem. I mean,
Fair
you can
enough.
hang outside with the.
I'm willing to do I'm willing to do combat outside the courthouse. I'll bring my javelin stick and fight off.
There's only 10 seats for the defense and 10 seats for the victim's family. So I was invited by the family to go. That's how I got in. Otherwise, there are no public seats. 10 for the media. That's it.
There are no public seats?
Nope.
Wow. Okay. That's
weird. Because it's in a really tiny courtroom. Because the big courtroom they were going to have the trial in had the jury box positioned so that half the jury was looking at the back of the witness's head. And Alan Jackson said, "That's unconstitutional." And Judge Bev said, "Well, we've been doing it this way for 100 years, Mr. Jackson. No one's ever complained before." So that's why it was moved to the small courtroom. This stuff keeps going on. She may just ban the cameras from the courtroom, and then the people are going to go crazy. People are going to go crazy. I mean, I like being in the courtroom, but I almost like being here at home, dissecting it with you guys live, because the courtroom's hot as hell. It's hot as hell. And you miss so much. It's kind of like going to a game or watching a game on TV. Like you pick up so much more when you watch it on TV. But of course, I will not squander the opportunity to go to court. But I will not be there every single day. Thank you so much, Snacks, for your thing. Uncle Fredo is here. Think about it. What was the urgency to remove the taillight in the Sally port? The fix was in early. Well, they had to pin it on the girl, Uncle Fredo. It was rhetorical. Just like fair trial in Norfolk County is an oxymoron. I thought about that the other day. Should that be a t-shirt? Fair trial in Norfolk County is an oxymoron. And I kind of like it. You could vote on that in the chat. I meant, can't the documents already given over be released by the defense or say that ARCA was hired by the FBI? Oh, you mean in the trial? Can they now talk about the FBI? Rule 14 addresses this. The new Rule 14 does mention something about federal authority. So I know you're going to like it, see? So I don't think we could talk about that intelligently until Kurt does his show, which I will promote for you, by the way. on the Rule
Aw,
14 differences. Of
thank
course.
you. That's
Of
nice.
course.
Aw.
Bev's Bish Schlapp is here. Seeing all the corruption on paper just makes it more egregious to me. Just sickening and sad that Karen has to live this nightmare. Ask Sacco and Vanzetti how that courtroom worked out. Yeah, Sacco and Vanzetti were tried in that courthouse. Did you know that? Glamis, due to the small courtroom, we may be arranging watch parties for certain days of
Oh, that'd
testimony.
be
Well,
fun.
the McAlberts do it.
I
So
could
can
take
you.
my setup on the road. I bring my mic and my camera.
Right.
I'll have a table at whatever random bar you got.
What do you mean? You
with
got to
the-
go to the waterfall. How do you not go to the waterfall?
We can
You
do it
gotta-
at the water. We can do it at the waterfall. We could broadcast from the waterfall. It'd be great.
No, it's great. You get a high top at the waterfall because you know that's
Yep.
better camera position, better for
Yep.
the laptop. You get a high top. You bring something to boost up the light. You know how to do it. I'm going to need to tell you how to do it. But yeah, that could be fun. That's where Vinnie Politan. I don't know if he was broadcasting from the actual waterfall, but he definitely was in Canton or in Canton broadcasting.
I need to contact their management and be like, can I camp out at your bar for 8 weeks?
Right, or 10, however long. Listen, I got to just be honest. The hotel selection around that area not so great, but maybe there are Airbnb options. Anyone who lives in Norfolk County, you may want to consider putting your house up on Airbnb for whenever this trial starts because you can make a lot of money probably. Thank you, Glamis. Thank you for telling Kurt. Is Kurt welcome to come to your private room? Yeah, there you go. Rubicon, I knew those high top tables would finally be important. That's so true. A high top for your laptop. See? You know what I'm talking about.
Love it.
All right, Kurt. Thank you for coming and hanging out with me today. I appreciate you so much.
I had a fun time. It was fantastic. We need to do this again.
It was really fun. I'm glad that people can put to rest all of these false rumors about a beef that we had. But thank you so very much. And all these people ordered shirts. You guys are awesome. All right, so we'll plan it again for soon. And I was talking to Runkle too about doing something. I'd like to do something. I'd like to do like a round table. I'd like to get you and Runkle and Andrea and Allie and Bob and do like, maybe we could do this about the ethics issue that, I think it's interesting. And I think having all of us talk about it would be great.
That could be fun. Don't forget to check me out at the channel Uncivil Law on YouTube. I do videos all the time, do live streams all the time, do a lot of U.S. Supreme Court cases in particular, try to keep up with what they're doing, federal appeals and other appellate courses, and of course, from time to time, trials such as the Karen Reed trial. So all those good things can be found at Uncivil Law. Make sure to subscribe today.
Today. Don't wait.
Do it now.
Plus, if you act
Do it
now, I will personally throw in a t-shirt that says, I went to Cancun with Melanie Little, attorney Melanie Little. No, I'm just kidding. I can't give t-shirts to everyone, but I wish I could. All right. I'll talk to you soon. Thanks, Kurt. Bye. Okay. All right, you guys. Wait, there's a couple more things here. And also somebody just sent me Alan Jackson's affidavit. So if you guys want to go over that, this is the affidavit that is attached to the motion to dismiss for egregious governmental misconduct. Let me take a quick, we're not done yet. We're not done yet, apparently, because if you guys want to do this, I got some time. I got some time. It's 147 pages. You were just looking at that affidavit. Yes, please. Yes. Oh, yes. Am I the first one to go over that motion, by the way? Let me just, you know what I want to do, though? I want to change the headline on my thing because my headline says something different, as does my thumbnail, but whatevs. Hold on. Talk amongst yourselves for a second. Oh, that's not where I gotta go. I gotta go to the studio. Talk amongst yourselves. Did anybody watch the 50th SNL thing? It was like Linda Richmond came in and was like, talk amongst yourselves. That's where I got it from, you guys. I'm for Clem's. Talk amongst yourselves. Sweater weather. It's Maya Rudolph, Amy Poehler, and Mike Myers. Is it Mike Myers that plays Linda Richmond? Or Linda Rickman or Richmond? All right, we're going to change the title to Breaking. Redacted. All right. So if some new people join us, they're going to be kind of sad that we're already how many hours into this, but it's what we do here. It's what we do here. Thank you. Thank you. Thank you. All right, let's just see if come with me, if you will, to the, well, that's the one that we just looked at. So that can go bye-bye. Bye-bye. Oops. We're now going to look at the affidavit of Alan Jackson in support of the defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. The redacted version, as you can see here. Oh, I was going to look at the thumbnails and see if this is exhibits or if this is all. Oh, yes. Okay. There are a bunch of exhibits here. So let's go. Let's go. Melanie Little's left swiping StreamYard is here. I shouldn't jinx myself by even saying your name. But she says, oh, she gives me a super sticker. Thank you so very much. Thank you so very much. OB Nurse Chelsea is here. How is it okay for Hank to accuse the defense of lying, saying they haven't turned over all ARCA stuff, when there is actual evidence that the Commonwealth didn't and hasn't turned over all the video evidence? Because, rules for thee and not for me. But look, I know you're a nurse, I'm a lawyer, but we're all living in the same twilight zone. We're all in on the same joke. We are all in on the same joke. If you thought that we weren't, we all are in on the same joke. Catherine says this is a great option for the Commonwealth to bow out. Use it. Yeah. Just as we went over the other day, I think it was last Saturday, I read to you the original Judge Cannoni order on her refusal to recuse herself that happened in the summer of 2023. We went over that. I had said many times, and I still am of the opinion that it would have been a great opportunity for her to bow out of this case. She could have said, I know. I mean, I do not know the McCabe's or the Alberts, and I also do not know the Nagels, and I've never rented out my beach house to anyone. And I don't know why Sean McCabe would say that, Aidan Carney should get buried under Auntie Bev's beach house. But just to avoid the appearance of impropriety, even just the appearance of impropriety, because that is my duty as a judge. That is what I swore to do. I'm going to recuse myself from this case, even though I really don't know these people. I really didn't do anything wrong. I'm going to recuse myself because it's the right thing to do. She had that opportunity. She didn't take it. Was that a mistake on her part? I don't know. We're going to see what happens, because let me tell you something. If what they're alleging in this motion to dismiss, most of which is redacted because we can't read it, this jury tampering issue with regard to Fanning being in charge of the jury, who, for those of you who don't know, was Proctor's supervisor, who was involved in the text messages. There was an internal affairs investigation after the trial ended on Fanning for not disciplining Proctor with regard to those text messages. I think he's the one who said he was on vacation, right? Didn't he say he was on vacation and he didn't get the messages and they cleared him? If Judge Cannoni appointed Trooper Fanning or Lieutenant Fanning, whatever the hell his title was at the time, to oversee the jury in the Karen Reed case, despite a clear conflict of interest, aside from the fact that the Massachusetts State Police are never assigned to oversee the jury, okay? It's a bailiff position. It's a court personnel position. It is never law enforcement, because that has been found to be per se jury tampering because of the intimidation factor involved with law enforcement overseeing juries. It's unheard of. Could that open her up to liability? So many of you have been saying, can't she be held to account for any of this nefarious stuff that's gone on? And we talk about judicial immunity, but it turns out that because she also holds an administrative position as the administrative judge in Norfolk County, perhaps her judicial immunity would be yeeted if this was found to be an administrative thing that she did. It could be a problem. Hell hath no fury And Carmen knows your address, basically, right? Which reminds me of something. Thank you, Catherine, for that. Also, before I forget, Monica Lewinsky did an amazing interview on Call Her Daddy the other day that just stumbled onto my timeline. Well, I guess because I follow Call Her Daddy, but I have always held a special place in my heart for Monica Lewinsky ever since she was crucified by the media and the public since the scandal in 1998. I commented on the video because Monica commented on the video, and I'm like, Monica, I would love to have you on my show. Like, she's all about anti-bullying. She's got an anti-bullying platform. She now has a podcast. She's got her own like YouTube channel, but it seems to be run by the podcast company Wondery. So I don't really know. I commented on the video. So many of you also saw my comment and also said, please, please go on Melanie Little's channel. Please, please, please. So I don't know how we can get to Monica, but I would love to interview her because of the special place that she holds in my heart. She's all about reclaiming her reputation and her name. And I mean, you know, if you know what the press did to her and the media did to her and the world did to her. She was a 24-year-old girl. It was horrific what happened to her. She's now all about anti-bullying. You know, I am too. And so I would love to, that Linda Tripp, that's what I said. That's what reminded me of it. I wrote, my comment was, Linda Tripp was evil incarnate, and Karma knew her address. So that was part of my comment. And then when I said earlier, Karma knows your address, it reminded me of the comment I made. So that reminded me to ask you to go to Call Her Daddy and comment on my comment to say, please come on the show. My comment is underneath Monica's comment. So yeah, that would be an awesome interview, right? So many things I want to say to her. She was a victim. Yes, but let's not get sidetracked. I just wanted to give you that. Her channel is called Reclaiming Monica Lewinsky. She's only got less than 5,000 subs. And also she's only got a couple of videos out. It's going to be interesting. I'm here for it. I'm here for it. Okay, here we go. This is the affidavit of Alan Jackson in support of defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. Docket number. Oh, it doesn't even have the number on it. I think it's docket number 522. 522. Because this is the way it's supposed to happen. You're supposed to attach an affidavit to your motion because you're swearing under the pains and penalties of perjury that everything that you put in your motion is actually true. Oh, really? She has a cameo, Monica Lewinsky? That's so cool. She does look beautiful. She does. And she's 51 years old right now. And she said something like, all of a sudden I turned 50 and it's like, I have no more ducks to give. Like, she thought about taking her own life. It was very sad. It was very sad what happened to her. I'm all about retribution for Monica Lewinsky. So I'm here for it. I, Alan Jackson, under oath, do depose and state as follows. I am a partner at the firm Worksman, Jackson and Quinn. I represent defendant Karen Reed, pro hoc vice, and also at this point, pro bono. That's what he said in the interview that we watched with Ted Daniel. They're not taking their money. I submit this affidavit on personal knowledge in support of defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. I have reviewed all the discovery produced by the Commonwealth in connection with this case. There is significant exculpatory evidence which has been in the Commonwealth's possession since January 29th of 2022 and was withheld from the defense at the first trial. The facts set forth in the instant motion to dismiss for extraordinary governmental misconduct are true and correct to the best of my knowledge. Attached here too as Exhibit A is a true and correct copy of the Stoughton District Court's February 2nd, 2022 order allowing defendant's emergency motion for preservation of evidence. Attached as Exhibit B is a true and correct copy of this court's October 5th, 2022 order allowing, in part, defendant's motion to compel discovery. Paragraph number 7 is entirely redacted. Paragraph 8, attached here too is Exhibit D, Exhibit I, Exhibit J, Exhibit O, and Exhibit S are true and correct copies of excerpts of transcripts from the first trial in Commonwealth v. Karen Reed. Attached here too is Exhibit E, H, K, and M are true and correct copies of video surveillance footage from the Canton PD captured on January 29th, 2022, which were produced in discovery by the Commonwealth on April 4th, 2024, April 23rd, 2024, October 10th, 2024, and January 28th of 2025, respectively. Attached here too as Exhibit F is a copy of the Commonwealth Certificate of Compliance, which was filed in this court on April 10th of 2024. So that was before the first, or actually, yeah, I think they said that it might have been, I don't remember the date that jury selection started, but that might have been like before the trial, but before the trial started, but while jury selection was going on. Does anybody know for a fact? I know you guys do. What was the date of opening statements? I will wait and see if anybody knows. But they filed their certificate of compliance April 10th of 2024, which is supposed to indicate that all of the discovery that they have has been turned over. All the discovery that they have has been turned over. Yet, video reveals itself magically during the course of the trial. That was inverted. Paragraph 11 is completely redacted. It was the 17th of April. April 17th, thank you. So this was 1 week before opening statements. I don't remember how long jury selection took. Paragraph 12, attached here too as Exhibit P is a true and correct copy of Lieutenant Brian Tully's May 29th, 2024 report memorializing his May 10th, 2024 interview with Jennifer McCabe, which was not produced to the defense until June 4th, 2024 as part of Notice of Discovery XLV. We're into like Super Bowl numbers now. All right, so exhibit, that's one of the things I want to look at first is Exhibit P. P for proctored. And that wasn't turned over until, after Jennifer McCabe was off the stand. And I was watching something. I've been watching so many things the past 2 days because I just can't even wrap my brain around this. Alan Jackson pointed it out in open court. It may have been the day of the voir dire of the Crash Daddies. And she said, well, what do you want me to do? Do you want to call Jennifer McCabe up again? And AJ's like, no, I don't want to call Jennifer McCabe up again. The damage that I did to her is already done. And the judge said, I'm sorry, what? What did you say? And he said it again. The damage that I did to her is already done, or something like that. Something very similar to that. So that report, Lieutenant Brian Tully's report, not turned over until June 4th, until after she'd already testified for the Commonwealth. Paragraph 13, paragraph 14, completely redacted. Paragraph 15, on October 10th of 2024, after trial in this matter had concluded, the Commonwealth produced additional exculpatory video surveillance footage from the Canton Police Department, establishing that Brian Higgins made a phone call to some unidentified individual on January 29th, 2022 at 1:34 a.m. Oops. Red pen, run amok. This video surveillance footage, which is attached here too as Exhibit K, was not produced by the Commonwealth until after trial on October 10th of 2024 in connection with Notice of Discovery XLVII. Special Prosecuting Attorney Hank Brennan indicated that he located this video footage on some sort of electronic device in a box that was in the actual possession of the Norfolk County District Attorney's Office while he was conducting his review of the discovery in this case. It's just in a box somewhere. The defense has set forth credible and unassailable evidence establishing that the Commonwealth has engaged in numerous and egregious Brady violations throughout the pendency of this case. The Commonwealth's repeated constitutional and discovery violations, which have ultimately resulted in the permanent destruction of exculpatory evidence, has caused Ms. Reed to suffer irreparable harm, and a fair trial is simply not possible. And I got to tell you, I got to agree. Had this stuff been turned over timely prior to the first trial, could have been a completely different result. Had this video been preserved properly from January 29th of 2022 in its original format on the ExacuVision system, which, as we know, because I have a viewer who reached out to me who uses that exact system somewhere in Massachusetts, you can put video on a legal hold, which will prevent it from being overwritten on the system without having to move it off the system. There's ways of doing that, technology and stuff. They didn't do it. And now that the judge has ruled no metadata for you, they shouldn't have to create metadata where it doesn't exist. Or we're living in the upside down. I'm telling you. How can she receive a fair trial? There's an entire paragraph that is also redacted. Paragraph 17. Paragraph 18 says Ms. Reed has suffered numerous and egregious constitutional violations as a result of the Commonwealth's brazen discovery and constitutional violations and juror interference, which denied Ms. Reed her Sixth Amendment right to a fair trial by an impartial jury. The interests of justice require that this court exercise its discretion to dismiss this case with prejudice. In the alternative, the defense respectfully requests that this court grant an evidentiary hearing such that the defense can call witnesses to further establish through sworn testimony that Brady violations and juror interference have occurred in this case. Signed and sworn to under the pains and penalties of perjury, February 21st, 2025, XOXO. Smooth as butter, Alan Jackson. And here are the exhibits. But where I want to go first is Exhibit P, because I want to see that. Well, Exhibit A, that's the original. We looked at this one day, but we can look at it again. This is the defendant's emergency motion for preservation of evidence that was signed in, it was court ordered in the Stoughton District Court on February 2nd, 2022. And so that was the preservation order there. Exhibit B. Defendant's motion to compel discovery. I want Exhibit P. Let's go there. They come bearing receipts. Exhibit P. Here we go. Let's hide the sidebar. This is a MSP report. It's dated May 29th of 2024, which is in the middle of trial. It is to First Assistant District, I should say District Attorney, but it just says First Assistant District Lynn Beland, who has since jumped ship and swam as fast as she can away from the Norfolk District Attorney's office. I don't know where she is now. Maybe somebody knows. From Detective Lieutenant Brian Tully. Subject, meeting with Jennifer and Matthew McCabe. And there's the case number. On May 10th, 2024. I'm going to point this out for those in the back who maybe didn't catch on. The meeting was on May 10th with Tully and the McCabes, but he didn't type up the report or memorialize it in any way because he didn't take any notes, according to Jennifer McCabe, on May 29th. Really? We're in the middle of a trial. You meet with her to specifically question her about going to Lank's house and or prep her for testimony, and you wait 19 days to render the report? Okay. I guess in some other world that is not this one. On May 10th, 2024, Jennifer and Matthew McCabe arrived at the office of the Norfolk District Attorney's Office. Jennifer was provided a copy of her grand jury testimony regarding Commonwealth v. Karen Reed. Matthew was provided a copy of his testimony. They read the transcripts in a conference room and returned the documents. This is trial prep for the McCabes. Notice how they didn't go to Jennifer and Matt McCabe's house for this. They made them come to the district attorney's office. Oh, here we go. Number 2, Jennifer requested to listen to her 911 call to Canton Police on January 29, 2022. Because now Jennifer is in charge of what she gets to see and hear. And notice how they don't call her Ms. McCabe, they call her Jennifer. Does that indicate to you some sort of familiarity with these witnesses? Because they usually don't call them by their first names. Police reports, do they? I played the audio file, and this is Tully who's doing this. Why is Tully prepping them for their testimony? Why isn't Lally prepping them for their testimony? Law enforcement does not prep witnesses for testimony. This is weird. This is already weird. Of course it is. Jennifer and Matthew requested to watch the Canton police cruiser camera video that depicts them both on the morning of January 29th, 2022. Also weird. It's not, we showed them these videos in preparation for their testimony. It's she asked to see the video, the dash cam video. Who's in charge of this investigation? Who's in charge of witness prepping for testimony? Where are we? I don't think I've ever seen this. Have you guys seen this? Was this ever made public until today? She needed to get her story straight, says John Monagle. Scott says totally improper. I played the portion of the cruiser camera that depicts the McCabe's on that day. So Trooper Tully or Lieutenant Tully is now making the determination on what the witnesses should be allowed to see before they testify? What? Tully is the one calling the shots here? Yeah, Tully's going to have to take the stand. Tully is the one who was in text message threads with Ken Mello, Masshole Mafia Kate Peter, and Lindsay Gattani to set up allegedly Aidan Carney to go to prison or jail. And now Tully's in there meeting with the McCabe's and showing them video and determining what they can or cannot see. Full melt hash values. You hear our entire police force is being taken down right now. This happens often. Somebody sent that to me. I think it was in Alabama. I think the entire police force got suspended because of shenanigans like this. I haven't had a chance to really look at it yet. The world is watching. Zoe, was the 911 call audio and dash cam video available to any civilian through FOIA? If not, then Jen McCabe shouldn't have been reviewing it without the prosecutors. Yeah, where are they? He doesn't say who else is in the room, does he? This is insanity. This is insanity. I asked Jennifer why her cell phone would have been in the area of the residence of Michael Lank, Canton Police Sergeant, on January 30th of 2022. Jennifer stated she was with Carrie Roberts, who was picking up her daughter at the residence. Well, that's funny because in her testimony, she said she was dropping her off. And in fact, they sat in the car. Well, wait, let's just finish what he wrote in his report because we know he didn't take any notes because Jennifer McCabe said so. Jennifer stated she did not speak with Michael Lank while out the residence. Do you remember that Jennifer also said on the stand that Tully didn't ask her any follow-up questions? Wow. She did not speak with Michael Lank. This is stamped Division of Investigative Services of the MSP, signed by Brian Tully, badge number or something, 3520, Detective Lieutenant of the Norfolk SPDU. And that's the entire exhibit. So, okay, just to recap here, Lieutenant Tully met with the McCabe's and apparently let them dictate what he was going to show them in preparation for their testimony. And it doesn't even say if there was any attorney in the room or prosecutor in the room or DA in the room. State Police Detective Unit, SPDU. Thank you, Mass Dad. Thank you. And I mean, this is the way the paragraph starts. I asked Jennifer why her cell phone would have been in the area of the residence of Michael Lang on January 30th, 2022. I asked her why. Because the defense was required to turn over that information to the prosecution. And so Tully is the one who prepped her for that. Plausible deniability. He's not an attorney. He has no bar license to lose. So let's have Tully do it. Yeah, I did know that Brian Walsh has a hearing today, and we were going to cover it until we got these documents. But if it's televised, I can do it on delay. I have the Zoom link and everything. I was going to do it, and this happened, so we were already here, 8,000 strong. So thank you, rehab department groups, and we can certainly cover that a little bit later. Because what happens sometimes is that they are they broadcasting it live? I don't know. Mastad, are you listening? Thank you, Mastad. Tully's hearing was not televised, just Zoom. Sometimes though, like in the Redington case where he mentioned me in open court, they dropped the video like a week later. So many of you pointed that out to me, that Kevin Redington said, Kevin Redington was Jennifer McCabe's lawyer, when he was at a hearing for the Dr. Turk's case, Ingolf Turk, and he was trying to get a change of venue, saying that everyone's talking about this case. He did say, there is a YouTuber who has a lot of credibility. Her name is Melanie Little. She's been talking about this case. And then, much to the chagrin of many people, they put it up on Court TV, on the Chiron, right in the thing. Melanie Little has been talking about this case. Wild. I wanted to watch that with you, but so many things have happened. We have not yet had a chance to. But that's crazy. All right, we can get back to that another time. So yeah, he's just heading it off the bed. I asked Jennifer why her cell phone would have been in the area of the residence of Michael Lang. And here's the thing. I think this was from her. I know where this is from, because when we watched Karen's part 3 interview of Ted Daniel, where they're sitting in the car, she said where it came from, that Richard Green was going through her location data and he found it, and they had to turn it over to the prosecution. And so they had the information too in her location data, and they could have figured it out themselves, but they had to turn over this exact thing. And so Michael Lank was the one to prep her on it. This is, you can't, not Michael Lank, Brian Tully. Wow. That's Jay says, about Boone's case, they billed for time watching lawyer, that's hilarious. That is hilarious. You can't make this up. You just can't. You can't make it up. Joanne said, interesting, at the last Brian Walsh hearing, his attorney said that Proctor and his cohorts were following Brian around months before Anna Walsh murder. They got that info from the feds. Oh, that's interesting. Huh. Jen also said that Allie was there at Lanks. Oh, on the Walsh hearing that's happening right now on Zoom, they are discussing the federal investigation being over and a letter they received from the DA discussing Proctor's texts and what is or isn't protected. The judge is very confused. Well, yeah, that Walsh's case had been assigned to Judge Cannoni, then it was taken away from her and assigned to another judge. The only good thing, thank you, Green found it. The only good thing about Karen's trial potentially getting pushed a little bit from April 1st is that Dr. Ingolf Turk's trial is supposed to start jury selection on March 25th. That is the one that Kevin Redington is trying. He's the one who allegedly and then confessed to strangling his wife, Katie McLean, and then dumping her body in a pond and putting rocks in her yoga pants. He was a world-renowned, apparently, surgeon. Can't remember exactly what kind of surgery right now, but I've done a bunch of videos on that case. And then we can do the Turk case before the Karen Reed case. let's go to the chat for a moment because I'm going to leave this up on the screen so that you can digest it to its fullest, what it deserves to be fully digested. Mara says, and Law and Lumber for the roundtable too. Thank you, Anna, for your suggestion. Have you ever had Turtle Boy on your stream? Yes, he's been on my show before. He has been. He was once when he was in the car. I think he and Will were in the car in different cars, and they both came on at the same time. And I forget what it was for, but yes, he has been. Thank you, Derek, for the 5. Can't wait to get my Melanie Little merch, says Mama She. Thanks, Mama She, for being a kind and very generous supporter of this channel always. Reserve Snark. Well done, Elizabeth Mullins. Well done for changing your name today. Thank you, Melanie, for all you do and for the time you spend it with. Oh, okay, ain't no place I'd rather be, girl. Look at you, Reserve Snark, changing it during the course of this stream. Got to call up the reserve tank of Snark. Found you by lurking and lurking still. I'm always here. Love you, Melanie. Thank you, Lois Lane, for being here for at least 6 months. I love it. I think she has a cameo. Thanks, Alicia. I think that was for Monica Lewinsky, right? Jadzia, if it were to be dismissed, could Karen sue for malicious prosecution? Yeah, I think she's got a lot of a very strong claim for violation of her civil rights, and she could. A lot of people think she could wind up owning, Canton, Massachusetts County. Very, very strong, very strong. Sandra, thanks for becoming a new member. Welcome. Nina says, why didn't the defense ask for dismissal during trial like Spyro did in the Baldwin case? Now the judge can say it's a new trial, no Brady violation. A couple of reasons. We don't know what they discussed at sidebar. We don't know. That's why this is being brought up now. We don't know what he asked. She may have said, go back to your table, Mr. Jackson. The difference is that in the Baldwin case, objections and things like that were in open court. They weren't hidden. We don't know. Sandra, thank you for becoming a member. Donna Malone. Donna Malone became a member twice. It says, I don't know how that happened, but that's what it says. RBG says, if Bev pushes ARCA out, they can get another crash expert, right? They can. They can. Do they have enough time? I think they do. Some people have said maybe they're short on time. I don't know. I don't think the trial is going to happen April 1st because of the federal habeas petition. And so therefore they would get more time. I also think that there's many an accident reconstructionist out there who may have been watching this trial and the shenanigans attendant there too. And maybe like, hello, can I help? Similar to what Dr. Russell did. And so I don't know that there may be, people that are familiar with the case that are ready to jump in. Who knows? But yes, I believe that they could. Hot Wheels. Jen also stated she was with Allie, not Matt. Oh, when she went to the DA's, when she went for this meeting. That's right. That's right. She did. She said she took Allie with her to the meeting. I remember because I just rewatched that testimony. Thank you, Hot Wheels. Oh, more perjury. Oh, that's funny. Mike Gallagher, thank you. Welcome for becoming a new member. Disney fan, thank you for your 5. Tennessee Cousin is so outraged, says, I honestly wouldn't be surprised if Santa prepped these witnesses. XOXO. There's another Melanie here. She says, lucky for Jen that she calls the shots in Norfolk. She'll want to get this case dismissed. I can't see her wanting to testify again. Interesting thought. Thank you, Melanie. It just did. I've been waiting days to hear this motion. Thank you, Melanie, for bringing it to us hot off the presses. Love your guests too. You guys have a fun report. Thank you. Kurt's been around the law tube streets far longer than I have. He's been here for a longer time, since like the Rittenhouse trial and the Amber Depp and Johnny Hurd trial. None of those was I here for. And so he's been around. Could a new accident reconstructionist use ARCA's reports? I don't think so. I think they would do their own. They would do their own reconstruction. I think that all the materials that they would need to do it already exist. They wouldn't use it. Could they review it? Probably. Could they also review Trooper Paul's report? Yeah. And that's one of the things that Hank likes to hang his hat on, Suze, is that, ARC experts didn't even review Trooper Paul's report. Why would you? Why would you? You're trying to come to your own conclusions and opinions, not point out all the horrible things that Trooper Paul did wrong. Although, if they were to hire a brand new expert, could they do that? Yeah. And you know what? It costs money. And so, therefore, anybody, it was Karen Reed's birthday yesterday. She turned 45. Any of you have an extra dollar to spare? I'm sure that she could use the money in her defense fund because this stuff is expensive. These appeals are expensive. And even though the attorneys are doing it for free, appellate printing alone is tens of thousands of dollars. Experts are very expensive, as you can see, especially when you have to pay them to testify, not just to prep their testimony by themselves, probably by reading over their own damn file and, their flights and meals. And they had to fly twice to Massachusetts. Really, it doesn't add up because if they were charging also for a day of testimony, that bill would have been way higher. Mama, she says, I had hoped for the dismissal motion until I heard Bev would hear it. Yeah, she's going to hear it. She heard it last time too. She's the trial judge. She's the gatekeeper, as you know. There was another exhibit that I wanted to see, and that was Exhibit K. Those of you who have already read this to yourselves in your spare time, if there are any other exhibits that are pertinent that you want to see, let me know. Exhibit K. Man, I got to make this bigger. Hold on. Talk amongst yourselves for a second. Well, Exhibit L is totally redacted. Exhibit K. Okay, yeah, so Exhibit K was a flash drive. That's the video of Higgins coming out of the Sally Port talking on the phone. And so there's that. Does anybody have the scheduling order? I think I have it, but it's probably buried. And I got to find it. And it's a whole thing. Nothing adds up. I know nothing adds up. Well, it's redacted. It's not impounded. It was impounded yesterday. That's when I made my community post. We didn't know if the whole thing was going to be impounded, but it has been redacted. It has been released into the court docket. It has been scanned in. And so I'm not doing anything wrong by talking about it. But thanks, Pam McKinnon. I know you care about me and my well-being. Pineywood says she likely won't, but Bev needs to dismiss this case immediately. There's no other remedy for these violations. I'm logging all violations. I agree. You're an attorney too, right, Pineywood? I know this hurts my soul. This whole case hurts my soul, but now that this whole juror tampering thing is now becoming an issue too. I mean, really? Who in their wildest dreams thought it would be a great idea to have Trooper Fanning overseeing the jury in this case? I mean, it's only the biggest case probably in Massachusetts ever. Now it's a worldwide story. Who thought that was a good idea? Dash cam of Matt McCabe that morning. What? Yep. Apparently something like that. Maybe. Well, thank you, Suzanne, for emailing me that scheduling order. I know it's always at the tip of your fingers. I love you with all of my heart. I love you with all of my heart. Let's just put that over here. Oh, okay. So filing of the defendant's motion to dismiss is the 21st, which was last Friday. So their opposition is in fact due today. The Commonwealth's opposition is due today, the 27th. Oh, and then it says the hearing on the defendant's motion to dismiss is going to be next week, 4th and 5th. This is the updated one, right, Suze? Yeah. Everybody's thank Lama Suze. Uh-huh. Yeah, so there we go. And then we've got the 6th all reciprocal discovery to be completed. Final pretrial hearing is supposed to be on the 7th of March, which is also next week. I don't know how they're going to cram all this in. Hearing on all motions in Lemonade, March 18th, 19th, and final final trial conference. And then trial on April 1st. I can't see it. I can't see it happening, but what say you? MLC, thanks for tuning in. Definitely could call the third ARCA guy. Problem solved. Maybe not. Maybe not, because they're going to allege, like they're already alleging the Commonwealth, that there's an improper relationship between the entire team at ARCA and the defense firm. I've never seen anything like this. I mean, this just it strains credulity the more and more and more that this goes on, the more and more and more my head is going to pop off. It is going to pop off. Tracy Walker bought me 10 matcha lattes. Thank you, girl. I'm going to need each and every one of them after this is over. Appreciate you all so very much. I'm going to need to wrap in about 15 minutes to drive the mommy Uber. So get your last questions in here. Justin, thank you so very much for your, as always, Venmo before the stream, who says, hoping people might start using Venmo. Would love to see you get 30% more pay than going to YouTube. Though happy YouTube gives me the chance to watch and listen to your show. Well, thank you very much. Thank you very much, Justin. This is, mainstream media is dead. And you know what's happening now? All of these like newscasters that are on Court TV and Law and Crime are starting like their own YouTube channels. You see it. Nobody's watching it. Nobody's watching it. And plus, you only get to talk about stuff for 2 minutes when you're on Court TV and Law and Crime, right? It's like 2 minutes. It's not however many hours we've been here, 4 hours and 14 minutes. For those of you just tuning in, you missed a lot today. You missed a lot. Kurt from Uncivil Law was here. He talked about the federal habeas petition with us, its chances of success, and some case law. Then the motion to dismiss for extraordinary governmental misconduct was filed by the defense. And we got to see a redacted copy of that. We read the entire motion. And then we took some questions. And then we read Alan Jackson's affidavit and looked at some of the exhibits. We're still camping out. Thanks. I got somebody emailed me that right after. And lunch was tasty. Good. You got to keep that blood sugar up. Vinny Politan, who I'm in an unofficial competition with for subscriber count. He's already beating me, but talking about the blood sugar. He has a whole song and everything, and he checks his blood sugar during every one of his lives. He's still beating me in subscriber count. But that's just one example of people that are or mainstream media people that are starting their own YouTube channels. So there's just one of those. Right, Iceman. And with YouTubers, we get to participate actively and ask questions instead of just believing mainstream media at face value. We get to talk about it. We get to be collaborative. We get to talk amongst ourselves, and you guys get to ask me questions. And I don't know what his blood sugar is, but he does it. There's like a whole song. It's like about the blood sugar, and then he checks his blood sugar and he's on the air. And I love it. Look, I love Vinny. I've been following Vinny since my early days of being a lawyer, when he was on the original Court TV and the OJ and all that stuff. And Aaron doesn't subscribe to Vinny just so I can beat him in subscribers. And I love you for that, Aaron. That's why you're so awesome. Just one of the reasons. We ain't got no quit, Eileen. We ain't got no quit. Let me just check the docket again, see if anything else has been filed while we're sitting here. I can't look at it right now, but at least we'll know about it. So here's the thing. You can't access documents in Massachusetts. People have been asking me, unless you're an attorney. And also, same thing with New York in criminal cases. Very hard to get. There are many states that let you look at everything. They're like Coburger. They're like, here you go, have it all. We even have a special page for it. You can get any documents you want. Mississippi is another one. Easy to get documents. When we looked at Carly Gregg, Florida, so easy. You just go out, you don't even have to pay. Federal documents I can get because I'm an attorney, and also because they charge by the page, and I don't really care. I'll pay for it. Yesterday, I took one for the team, and I paid for and downloaded the federal habeas stuff, the opposition stuff. And then through this court listener website, because I did that, it populates to that website as well. So then people can see it for free. So look, every now and then you got to take one for the team. I don't mind paying for it. I just want to have access to it. All right. So let's see. Yeah, no, the last thing was 522, which we looked at. See if there's anything else that was sneakily denied or granted by the judge. Yeah, the defendant, Karen Reed's motion to impound certain portions of the defendant's motion to dismiss was allowed. That is dated yesterday. And so then today, that's why we saw the redacted copy suddenly appear magically, deliciously in the docket. Oh, really, Cindy? We could access documents last year if you're not an attorney in Massachusetts? It changed after the trial? I thought even pre-trial I had trouble accessing documents. I don't remember. Now I can't remember because, it's been so damn long. Yeah, I should get Vinny on the show. He was on Defense Diaries the other day for the whole hearing. Well, not for the whole hearing. He was only on for like an hour because he had to go. Because I watched it. I went back and watched it after. I'm like, Vinny and Defense Diaries are going to be together and they're going to be up against me. I have competition. And then I had like, you guys were like 15,000 strong for the entire day. You guys are amazing. That's crazy. I don't care, Suze. It was $5. What do I, come on. You're super chatting for it. Edward Lally pretrial claimed he had been in contact with the lab, but the lab logs showed the times he claimed he talked to them showed no communications. Well, just add that to the list of things that Lally misstated. And also, he was basically absolutely accused of ethical violations in this motion to dismiss for many reasons. All right. So that's it. That is it. All right, my friends. I love you. All of my heart. If I don't see you again soon, I'm going to die. Go watch The Godfather and find that scene. And you'll laugh every time you see it because, I brought it to your attention. Maybe some of you already knew about it. Thank you to the moderators for keeping the chat classy today. This is never, ever, ever an easy case to cover because even though I often have the chat set to a one-day subscriber level, the trolls always find their way in and they're on it. It's like whack-a-troll. It's like whack-a-troll. Like they're on it quickly. So thank you to the moderators. Thank you to the channel members, my cupcakes. I love you so much. Thank you to viewers, replay viewers. Smash the like button, help a girl out, hit the subscribe. Make sure all notifications are set because when I have breaking news like this, if I'm not already on the air, I'm going on. And you might not get a notification if you don't have it set to all. Do all the things that YouTube likes. If you need your I Went to Cancun with Melanie little shirt, the link is pinned at the top of the chat. Stay cool, stay kind, stay classy. I'm going to see you guys real soon. Don't worry. I can't go very long without seeing you. Peace, my friends. Peace. Have a great rest of your evening.